Well, good morning, everyone. Can I just confirm that those who are participating online can see and hear us? See Ms. Bell's there. Yep, thank you. Welcome to day one of the EES hearing into the Goschen Mineral Sands and Rare Earths project. The hearing is being held in a hybrid format that is a mixture of in-person and online. My name is Michael Kirsch. I'm the chair of the EES Inquiry and Advisory Committee, and I'll be referring to us as the committee. My colleagues on the committee are Ms. Alyssa Bell and Mr. Colin McIntosh, and we're being assisted by Ms. Amy Selvaraj, who's the Acting Manager of Major Projects at Planning Panels Victoria. This morning, Ms. Bell will be joining us online, and we hope that she'll be with us tomorrow. Firstly, we'd like to acknowledge the traditional owners of the land we're meeting on and pay our respects to the elders past and present and to the wider Aboriginal community. Now, can everyone please note that today's hearing is being audio recorded and that the links to the recording will be made available on the Engage Victoria website within a day or two of the recordings being made. Consistent with the directions we issued on the 15th of February, the hearing is not to be recorded by other parties. An invitation to the hearing has been sent directly to all submitters, and a publicly accessible link has been placed on the Engage Victoria website. The hearing will be conducted in public, and we might also have a number of observers with us today, so welcome to everyone. Just some notes on how to use the Zoom platform for those that are joining us online. If you're a submitter and participating online, please include your first and last name in the participant list. And if you're representing an organisation, include your organisation name after your name so that the committee can identify you. Instructions on how to do that were included with the letter advising you of the hearing arrangements. Just a couple of etiquette rules. Submitters should put their microphones on mute until I ask you to speak. And if you'd like to speak, please use the raise your hand function. People who are observing the hearing should have their camera and microphone switched off. And if anyone's experiencing any technical issues or needs support during the hearing, please contact the proponent's technical support at Resource Design on 0493 452 288. So that's 0493 452 288. Now, we need to work through a number of preliminary matters this morning, but before we do that, can I ask those who are speaking today or who intend to raise any preliminary matters to introduce themselves? We might start with the proponent and Mr. Porter.
Good morning, Mr. Chairman, members of the committee and parties. My name is Emily Porter. I'm a barrister. I'm appearing today with Mr. Rob Forrester, who's to my left, and we'll also have Mr. Rupert Waters joining us. There'll be days when it's one, two or three of us because of timetabling constraints. We're instructed by White and Case sitting behind me, and we're acting on behalf of VHM Limited, which is the proponent in this case. I do also have three preliminary matters when we get to that.
EPA.
Good morning, Mr. Chairman. My name's Serena Armstrong. I'm the barrister appearing for EPA. I'm instructed today by Olivia Williams. And we also have other EPA staff attending, such as Guido Soares, and there'll be a number of staff attending online through this hearing. Thank you.
Thanks. Impact Assessment Unit.
Good morning, Chair. My name is Cameron Pearce. I'm a Senior Impact Assessor in the Impact Assessment Unit within the Department of Transport and Planning. We're responsible for the administration of the planning assessment functions under the Planning Environment Act, EPBC Act, Bilateral Agreement, Environment Effects Act.
Thank you. And do we have any representatives from either of the two councils?
Good morning, Mr. Chair. David Bergen, Agency Planning, the contracting for Swan Hill rules the council. I've seen Ms. Granger has dialed in remotely.
Okay.
Between her and myself will be hearing when we're available. Yep. Either in person or remote.
Thank you. Anyone from Gannawarra Council? No. Okay. And Mindfree Mallee Farms.
Good morning, Mr. Chair. Michelle Sharp, barrister. I'm instructed today by Dimina Tanik, who sits to my left.
Welcome.
We also have 3 preliminary matters that we hope to address when convenient.
Anyone else wanted to raise any preliminary matters or anticipate speaking to us today? No.
Chair, there's someone online, Joanne Eastman.
Ms Eastman.
Good morning, Chair. There were several matters that I wrote about in an email to you, and you said that I could raise them in the preliminary matters today, so I'll be wanting to do that. Thank you.
Hopefully, in the matters that I'll be raising first, I'll cover off on all of those, but if I don't, then by all means, we'll give you an opportunity to raise any additional matters. Thanks.
Very good. Thank you.
We've also got Ms. Carruthers with her hand up too.
And Ms Carruthers.
Thank you, Chair. I do have a preliminary matter that I was given the opportunity to raise as well. Thank you.
Okay, thank you. Yes.
One preliminary matter regarding the bus tour. And the letter.
Yep. And your name, sorry, is?
Craig Kennedy.
I'm going to discuss the site inspection a little bit later. And if you feel you need to add anything to that, then by all means, we'll give you that opportunity. Thanks. No one else? Okay, thanks. As I said, there's some preliminary matters that we need to discuss, and after that, we've done that, we'll provide people with an opportunity to either respond or to raise their own matters. Firstly, any members of the media present? No? Okay, thanks. Can everyone note that we've been progressively uploading documents to the Engage Victoria website? These documents include administrative documents such as timetables and directions from the committee, as well as submissions, evidence reports and conclave reports from the proponent and others. Now, I won't go through that document list in any detail other than to note that last week we uploaded the proponent's Part B submission and a range of supporting attachments. They're documents 88 to 98. There's also a number of emails and correspondence in relation to some issues that we'll discuss this morning as preliminary matters, and we would encourage parties to monitor the Engage Victoria website and the tabled document list to make sure that you're up to date with the correspondence that's been passing between various parties. Now, in terms of the accompanied site inspection, as we discussed at the directions hearing and in subsequent correspondence from the committee, we'll be conducting an accompanied inspection as part of the hearing. The inspection will be held on Tuesday, the 2nd of April. Details of the inspection are included at documents 38 to 42 on the Engage Victoria website. At last count, 15 people will be attending the inspection in addition to the proponents' representatives. I should also note that we might also be inspecting the proponent's Kerang facility. That would be as part of a separate inspection, and we'll discuss the arrangements and details around that today. We've received correspondence from 2 submitters who have suggested that we should be visiting additional farms in the area to gain a better appreciation of the impact of the project. Can I just make some observations about that? At the directions hearing and in subsequent correspondence from the committee, submitters are invited to nominate sites for the accompanied inspection. Apart from the project site, only one privately owned property was nominated through that process, and we've agreed to visit that property. We weren't invited to inspect any other properties, and obviously we can't go onto privately owned land without the consent of the landowner. If we feel that we need to visit or view additional sites as the hearing progresses, then we'll make arrangements to do so. We've also received various correspondence from submitters about the committee's request for further information, and I'm sure you're all familiar with that document. It's document 5, and there were concerns also about the adequacy of the information in the EES. That correspondence was tabled as documents 8, 9 and 25. The committee's response to those matters were tabled as documents 10 and 52, and I won't repeat all of the commentary in the committee's responses, except to note that the committee is satisfied with the scope of the RFI at this stage of the process and will continue to ask questions of the proponent, its experts and others as the hearing progresses. We're in the process of reviewing the proponent's responses to the RFI in document 94, and if we need further information or clarifications, we'll be directing that it be provided. We'll also ensure that other parties have a appropriate opportunity to consider and respond to any relevant additional material provided by the proponent. As I indicated, Ms. Porter, we're in the process of reviewing that response to the RFI. We would hope to be able to provide you with some written advice about some matters that we're seeking some further information about or clarification about later this week.
Thank you.
We also received correspondence from submitters in relation to the accuracy of the proponent's summary of themes raised in submissions document. That summary is document 15, and the correspondence in relation to it is documents 30, 36 and 64. The correspondence from submitters was tabled and provided to the proponent, who responded in document 67 and provided a revised summary document in document 68. The summary document was provided as part of the proponent's Part A submission and in response to the committee's direction 11C that the proponent provide a high-level summary of the key themes raised in submissions. The committee is satisfied that the proponent has complied with that direction. However, we note that our consideration of issues will rely on our reading of the submissions themselves and not on the proponent's summary. The committee has also received an email from Mindfree Mallee Farms in relation to how the Minister for Planning intends to consider the project. That email is document 71 and it was received on the 17th of March. More specifically, that email noted that there had been some announcements from the government about the approvals process for renewable energy projects, and it sought a direction from the committee that the Department of Transport and Planning Impact Assessment Unit advise whether the existing planning approval process for the Goschen project had changed, and if it had, how it had changed. That email was tabled and circulated by the IAC. A couple of observations about that. Firstly, the committee's role and process haven't changed. We're acting in accordance with the conditions of our appointment and our terms of reference, and if those changed, obviously we would advise the parties. Secondly, if the Impact Assessment Unit wishes to respond to the submission or request from Mindfree Mallee Farms, that's really a matter for it. It's not a matter for us, and we won't be issuing any directions requiring it to respond. I'd now like to discuss two evidence-related issues, and they are the economic evidence of Mindfree Mallee Farms and the proponent's groundwater evidence. In relation to the economic evidence of Mindfree Mallee Farms, we've received a number of emails from the submitter and the proponent in relation to the evidence report the evidence intended to be called by Mindfree Mallee Farms. An evidence report was circulated on the 18th of March and is document 74. It's a 1.5-page unsigned document we understand was prepared by Mr. Lightfoot and Mr. Malcolm. The proponents raised various issues about this evidence, including the content of the evidence report, the role of the two experts whose names appear on the report, whether and when a conclave might be held. We have encouraged the parties to resolve these matters between themselves, and we understand there were some discussions held last week, but there are still some unresolved issues. It would be helpful, Dr. Sharp, if perhaps you could give us an update on where those discussions currently are, and once you've done that, I'll ask for the proponents' views as well.
Certainly, I don't believe that the discussions have resolved anything. So it's Mindfree Mallee Farms' position that it seeks to have that evidence admitted, and will call Mr. Lightfoot. The issues that are raised by the proponent, as indicated in the correspondence, can be dealt with by asking those questions of Mr. Lightfoot directly. In terms of the extent to which he has been assisted in preparing the report or giving evidence from Mr. Bill Malcolm, Professor Malcolm, he can give evidence of that. I note, for example, that his position would be no different from many of the proponent's own experts, in which they've been assisted by the work of others. So Mindfree Mallee Farms sees no difficulty with that. I note, of course, also the terms of reference at paragraph 32, which of course require the committee to conduct this hearing in accordance with certain specified principles. which includes natural justice with a minimum of formality, and that the purpose of the committee's task is to be exploratory and constructive, and otherwise discourage adversarial behaviour. That of course is consistent with the principle, those principles of course are consistent with section 161 1 of the Planning and Environment Act. I note in particular section 161 1D, in which this committee is not bound by rules of practice as to evidence, but may inform itself on any matter in which it thinks fit. So having regard to those principles, Mr. Chair, and given the task that's before the committee, it's mine, Free Mallee Farm's position that the expert evidence of Mr. Lightfoot on economics could be of significant assistance to the committee, particularly in circumstances where there is no other evidence available, there is no other contradictor. So notwithstanding non-compliance with the practice note, given the principles that I've referred to and your powers under section 161, it's mine, Free Mallee Farms that this committee would be assisted by Mr. Lightfoot, who is highly qualified. I believe you provided with a copy of his CV, which runs to no fewer than 10 pages.
Substantially longer than the evidence report.
Yes. And of course, I'm instructed that Mr. Lightfoot will be available to give evidence in person. And of course, mine, Free Mallee Farms would be prejudiced if you could not adduce expert evidence from him.
Ms. Porter.
Thanks, Mr. Chairman. I think it's fair to say that there has been a narrowing of scope regarding the objection following the discussions that occurred last week. In essence, we don't object to the filing of evidence by Mr. Lightfoot. We understand that it's no longer pressed that Mr. Malcolm would be effectively adducing evidence without actually turning up. We understand that the evidence is to be adduced by Mr. Lightfoot. We don't object to that. We don't object to the filing of late evidence, and we don't object to a late conclave. What we do object to, though, is the filing of a statement in non-compliant form, in substance and in form. Now, just to go to, and everything that's been said about your powers and the limited constraints you have on how you organise proceedings is of course accepted, and we don't disagree with that. But Planning Panels Victoria does have a guidance note about expert evidence. It is a guidance note that we've understood to be applicable to the evidence in this case. Our witnesses have complied with it, and I don't believe we raise any issue with any of the other MFMF witnesses in that regard. This particular report, it's not just a matter of its length. It is not signed, so there's no declaration to the effect that Planning Panels Victoria's guidance note would require. It doesn't contain a set of instructions that were provided to Mr. Lightfoot, so we don't know the task he was asked to do. More particularly, and there is some substance to those more procedural matters, but more particularly, this report, contrary to the guidance note, doesn't set out the facts, matters and assumptions upon which the report proceeds. It doesn't reference documents and other materials witnesses taken into account. Whether there are any or not, I don't know. And it, more critically, doesn't actually contain a summary of the expert's opinion or opinions. Rather, almost half of it is just posing questions. Now, that's really, in truth, not an expert witness statement. It's a critique, if you like, of work that's been done. It may well inform submissions. It may well inform cross-examination. It's not, in truth, a statement of expert evidence. And so all we ask is that Mr. Lightfoot, if he is intended to be called to give economic evidence, provide a statement that's in a compliant form. And we otherwise don't resist, for example, him telling us the extent to which Mr. Malcolm has contributed to that work in like way for our experts. We really just make that one, I suppose, insistence on the calling of that evidence.
Okay, thanks. Dr. Sharp, I just need to make sure that we understand what your client's position is. It seems to us that there's potentially a fairly quick remedy to some of the concerns that the proponent has in terms of the formatting and supporting information that might be appended to or attached to the evidence report that you've already provided, and they're really, I suppose, administrative rather than substantive additions that you might make. Is that something that you're resistant to doing, or?
I'll have to take some instructions. The difficulty here for MF is that it's privately funded, has had to locate and instruct these witnesses on a very short time frame. And so the challenges with some of these experts is their availability to be able to provide that additional information. My instructions are that Mr. Lightfoot is available to give evidence in person. With respect to the objections that have been raised, for example, there's no declaration. Well, Mr. Lightfoot can in person give that declaration, can set out what his instructions are, can set out what assumptions he's relied on and what material that he's relied on. All of that can be remedied by Mr. Lightfoot in person.
It would be certainly more convenient and transparent if we could do that in writing before he presents his evidence.
I'll get some instructions on that.
Look, we won't make a decision. We'll wait for you to just further consider the matter. But it seems to us that setting aside the merits of the evidence or the content of the evidence, that there are some matters that we think you do need to address, and that's in terms of the compliance with the practice note, which was the direction of the committee at the directions hearing, and it's only very late in the process that that's been challenged. It could have been raised earlier, but it wasn't. But we would think that as a minimum, you would need to address those elements of the practice note that relate to report form and content and experts' declarations. And we would be happy to give you some time to do that at some point at the start of next week. But as I said, we'll let you consider or reconsider your client's position on that. So advise us a little bit later in the day.
Mr. Chair.
In terms of conclave, we think it would be useful to have a conclave, but only obviously that can be organised for a mutually convenient time. But if it can't be, then we'll accept that it not be held. That's really going to be a matter for the two parties. That's one other matter that I was describing in relation to having two authors for the evidence report. It would be helpful for us to have, and this is probably tied in with the comments I made earlier, but it would be useful for us to know which author authored which elements of the evidence report. And effectively, if your position is that they've co-authored, then that's fine, we can live with that. But if there are points of distinction between what they contributed, then we would like to know that. I think it's fair that other people know that as well.
Thank you, Mr. Chair.
We've also received an email from Ms Tannock on behalf of Mindfree Mallee Farms in relation to the groundwater evidence provided by Mr Fawcett on behalf of the proponent. The evidence report is document 27 and it was circulated on 7th of March. That email is document 100 and it was circulated on the 21st of March. Again, Dr Sharp, if you'd just like to explain what your client's position is in relation to that evidence and what your concerns are.
Certainly. The client's position I'll put simply and then explain why MF has those concerns. And that is that this more recent report, I'll call the Williams report, which is exhibit to the expert statement of Mr Fawcett, has not been exhibited. Unlike the earlier report of Right Solutions, which was exhibited dated 25th of November 2022 and was exhibited. So the position of my client is that this report ought to be exhibited for public comment, and that MF and any other parties ought to have the opportunity to obtain responsive expert evidence. So of course, Mr Chair, you'll be aware that the scoping requirements require or set out the purpose of the EES, which is to provide sufficiently detailed description of the project and assess its potential effects on the environment, as well as any alternative project layouts and designs and approaches to avoid and mitigate effects. And that the EES should enable stakeholders and decision makers to understand how the project is proposed and to be implemented and the unlikely environmental effects of doing so. And so specifically refers to technical reports to provide the basis for the main report, and that these reports are to be exhibited. Indeed, Appendix A to the scoping requirements requires these to be exhibited for a period of 30 days for public comment. And these documents, although they've been circulated to submitters, have not been available for public comment. There may be members of the public who may have issues with the assumptions that are stated in the more recent report, which are a stark contradiction to the Right Solutions report. The Right Solution reports indicates that at paragraphs 27 and 28, that ilmenite contains high levels of chromium. Paragraph 28 identifies a high potential seepage of chromium from tailings in major concentrations. The Williams report, however, says something quite different, and that is chromium tailings would be significantly lower. So it's a very different position. It's a changed position. And that was a position that was accepted by our client. Our client didn't, that is the Right Solutions position, wasn't a position that our client cavilled with. Our client accepted that position and accordingly made the decision to engage an expert, Mr. Philip McCummer, who, working off that assumption, only gave expert evidence in respect of those parts of the report, technical report and expert evidence that deal with dispersal of contaminants. So if this report is accepted by this committee, if this committee takes into consideration this report, members of the public and of course my client will be denied procedural fairness in obtaining a meteorologist or a geochemist who can take issue with the conclusions that are made in the Williams report in terms of the level of contaminants. Added to the issue of a lack of procedural fairness, I also submit that without that report being exhibited, that for this committee to consider the report would be to stray outside the terms of reference. The terms of reference make it very clear that what's to be examined and investigated and considered by this committee is the project and the exhibited documents. This is not an exhibit document, and it's a significant exhibited document in terms of the concentrations of contaminants of concerns from the tailings.
Thanks. Just a couple of follow-up questions. You said the document wasn't available to the public. It was lodged on the expert evidence report, and the attachment was lodged on the 7th of March. I assume it was uploaded on that day or the following day, so it has been available for some weeks.
Oh, my apologies. I thought it only been circulated amongst the submitters. I hadn't appreciated.
That's correct, but it has been available on the Engage Victoria website from either the 7th or the 8th, as I understand it. So it was accessible for any member of the public or any other submitter.
If I could just draw two issues in respect of that. The first.
Well, first, I'm just trying to clarify that was the case, and you know that was. Yeah.
So I don't take issue with that. What I say though flows from that are two things. The first thing is that the public aren't alerted to the fact that one of the fundamental bases upon which this project is put in terms of environmental risk hasn't been made clear to the public. It's come some time later. The second issue of concern is that is after MF has engaged its own expert.
I just understand what you're putting to us about that. I just wanted to clarify that issue about whether the document was available for public review or not. That's what I needed to do.
I understand. Thank you.
I suppose just if I just get you to respond to another proposition, and that is that it's not uncommon for new material to become available either prior to a hearing or even during a hearing itself for these types of processes. And that's often accepted. In fact, it's usually accepted. I'm just wondering why we should take a different view in this case.
Two reasons. The first is that this is a significant piece of new information, significant in terms of the risk that is posed to the environment, in particular the groundwater, by this project. Second is, had this significant piece of information, this significant report been made available sooner, my client would have sought to produce expert evidence to respond to it. Because, of course, as I've mentioned earlier, it was only made available after we had briefed our own expert hydrologist who worked off those assumptions in the earlier report. So if those concerns, Mr. Chair, my client doesn't seem to be obstructive, but that those are, in my submission, legitimate, important concerns of procedural fairness. And if those issues can be addressed, then there would be no difficulty for this report to be considered by the committee.
So what are you seeking from us?
The opportunity to adduce expert evidence to respond to this report.
And in a practical sense, what does that mean?
To adjourn the matter off, or such part of this hearing off, to enable that to occur.
So you can't anticipate that being done within the time frame of the hearing?
We're currently making inquiries, but at this stage, and we can certainly update you on our progress, that doesn't seem likely. Experts are expensive and experts require time. It's a report. Whoever's report is a report of some 240 pages. So an expert will have to be found, an expert will have to have time to consider that and prepare their own responsive report.
Thanks. Ms. Porter.
Thanks, Mr. Chairman. Just by way of background, the ATC Williams report deals with the geochemical characterisation of the tailings materials. The background to that is that VHM engaged ATC Williams in mid-2023 to commence work on the front-end engineering design of the project, of tailings management, the tailings management component of that design, which included analysis required in the preparation of the project's plans and procedures for the management of tailings. So in other words, assuming that we can go forward with this project, it's coming into the detailed design component of the project. And the purpose of that front-end engineering design is to input to the project's contract engineering procurement process, and really had nothing to do with the EES process. The scope, which is still ongoing, that ATC Williams was engaged with, includes progress on specifications for tailings pump or pipe types, tailings spigot or discharge points types, and spacing to achieve optimum deposition of tailings within the tailings cells. The aim of the work was to put the project in a position to be ready as soon as possible if the outcome of this process is positive. The reason it's come forward is because it was actually Dr. Watts, who we had understood was the metallurgist who's been retained by MFMF. You may recall, posed a series of questions, which we, I think, tabled for transparency's sake. And question 4 of those questions caused us to go away and say, well, do we have any of this information? Yes, we do. We have this report in draft form for a different purpose, but that assists in answering those questions. Accordingly, and you'll have seen in our response to Dr. Watt's questions, there's reference to this report. Dr. Fawcett then annexed it to his expert witness report. We had understood the purpose of having responsive or sequenced expert evidence was so that there was an ability to respond to expert evidence. And sure enough, Dr. Watts in his expert evidence, probably a very significant proportion of his evidence is devoted to this report. So we don't really understand the point that there's not been an ability for a metallurgist expert witness or MF to deal with it, given that he does, and indeed it's been then the topic of conversation in the radiation conclave. We don't have any objection to Dr. Macumber reviewing this report and filing supplementary evidence. Of course, that's fair if he, for whatever reason, didn't have the opportunity to review Dr. Fawcett's report and its attachments prior to preparing his expert evidence, and that seems to be what's transpired. We have no objection to Dr. Macumber reviewing the report and saying what he needs to say about it. That's really our response to, and it sounds like there's two components to the objection. One is the expert ability to respond, and I think I've dealt with that through Dr. Watts, who has responded, and Dr. Macumber, who we're prepared to hear a response. In terms of the public responding to it, that's a slightly more curious way of responding to information that comes to light during a hearing. If we were obliged to be exhibiting formally every document that came before an inquiry such as this, we would never get to the end of the process. Turning briefly back to your terms of reference, the IAC may inform itself in any way it sees fit. It is an inquisitorial rather than an adversarial process, and it must review and consider by term 31 of the terms of reference any information provided by the proponent and parties that responds to submissions or directions of the IAC. So here we have questions from an expert witness. We understood it was also partway responsive to some of the EPA's concerns. And you're also required to review and consider any other relevant information that's provided to or obtained by the IAC. I do query, I suppose rhetorically somewhat, what is the purpose in public exhibition of draft information that is responsive to questions raised by experts that is of itself of an expert nature? In other words, it's not readily amenable to public consultation or discussion. It is fairly expert subject matter, and that's why we understand Dr. Watts has devoted so much time in his report to dealing with it. So we say that there's no benefit to having an additional public process for this beyond what we're all engaged in right now. We would say that the way to deal with this is Dr. Watts has already said his piece on this report. If Dr. Macumber would like the time to respond, perhaps through supplementary written material, we have no objection to that. But we take issue with the notion that this report somehow completely upends the project as assessed in the EES. The report was not even designed for this process, so it's a work in progress.
Okay, thanks. Look, we won't make a decision about that now. I'll just discuss with my colleagues. And we'll...
Mr. Chair, if I could just stress one point. It won't be Dr. Macumber who will be able to respond to this report, just as Dr. Fawcett relies on the report, doesn't give this evidence himself. This really is within the field of expertise of a geochemist, so we would have to engage a separate expert.
Mr. Chair, you might not have seen Ms. Eastman has her hand up as well.
Ms. Eastman.
Thank you, Chair. A couple of things about the points that Ms. Porter was just making. The public has only 30 to 40 days to respond to information in the EES. It relies on information being correct and not being changed. And many members of the public have a lot of experience and expertise in these areas, even if they're not to be called as experts. It's most unfair to put something into this process that people from the public who have a deep interest in this subject matter don't get the chance to respond to. and that was the basis of my email to the chair, the lack of information that should be in the EES that we're responding to. I don't believe you should be excluding the public from information that's necessary. There's many people with expertise.
Well, there's no suggestion of information being kept from the public, Ms. Eastman. As I said, I'll have a discussion with my colleagues and we'll make a decision either later today or it's a preliminary matter tomorrow morning.
I'm sorry, Mr. Chair, just one matter that might flow from that decision. I understand there is to be a conclave between the hydrologists. So it's not clear whether this report ought to form part of that conclave or not.
I think it would be prudent that it did form part of that conclave up until we've made a decision about how to proceed.
I don't believe our expert has considered it in that report. So well, in fact, I'll have to get some instructions. I'm not even sure if you can consider it.
Well, if you can't consider it, then you can't consider it. I think if they're meeting and they can resolve or form a view about some of those issues, that would be a positive outcome for the process. If they can't, they can't. Let's let them meet and see what comes from that. Do you know what time they're? 3 today. 3. Well, we might get back to you after we come back from lunch, provide you with our decision on that.
Thank you very much.
The next matter that I wanted to raise was in relation to a potential change to the pipeline route. We understand that the evidence of Dr. Callister recommends that the A2 pipeline route be adopted instead of the A3 route that was preferred in the EES. That evidence report is document 28. Ms. Porter, can we just foreshadow that we would expect or hope that the proponent could be able to advise us during this process of its preferred option?
Yes.
And if the A2 route is now preferred, or if it's a live option, what are the implications of that? And specifically in terms of public knowledge of it having been an option in the EES documentation. I note, for example, that there was no mention of that option 2 in chapter 3, which is the project description chapter of the EES. Secondly, to what extent the environmental effects of option A2 have been assessed and documented in the EES and in evidence. And thirdly, whether any further investigations, consultation or notifications are required in order to properly assess the environmental effects of option A2. Now we can put that in writing to you if that would assist, and we're certainly happy to give you some time to respond if you had any preliminary response that you wanted to make at the moment. That might be helpful.
At the moment, we don't express to the committee a preferred route. We accept that there may be flow-on effects of a different route that, of course, aren't necessarily relevant to a flora expert, but might be relevant, for example, to a noise expert and so forth. So we're making inquiries with the witnesses as to their assessment of that. And I note that the EPA has effectively signalled the same thing. What are the flow-on effects of this, which is an absolutely fair question. Background to it, the reason it's come about is because following significant rainfall, when further surveys were undertaken in January of this year, there was an EPBC Act listed community that wasn't visible or known about prior to the time. So that's why Dr. Callister has come to the view that it would be preferable not to impact on that listed community. And that's how she's come to form a different view about which alignment should be proposed. As to the flow-on consequences, it's a little difficult to respond to that without knowing what the expert assessment might be of those flow-on consequences. So we'll need to come back to you.
Yep, that's fine. And when do you anticipate you would be able to do that?
I'll come back to you on that. I think. I don't know that we need to have you reduce that to writing. I think we'd already appreciated this issue, so we'll have to come back to you more formally, I think.
Now, just some administrative matters that I need to deal with in relation to uploading documents, asking questions of expert witnesses and the time allocated to mine-free Mallee Farms at the hearing. First, in terms of uploading documents, the committee directed the proponent establish and maintain a document sharing platform so that documents from the proponent and submitters could be uploaded during the course of the hearing. These directions are included in the committee's letter issued on the 15th of February and tabled as document 6. The proponent has established a Dropbox for uploading and sharing documents and has provided instructions about how to use it. These instructions are provided in documents 82, 83 and 84. Submitters should make themselves aware of that process if they intend to lodge additional written or other material during the course of the hearing. Direction 35 in the committee's document 6 requires that any party who intends to question an expert witness must provide written notice to Planning Panels Victoria by 3 p.m. the day before the witness is to appear, including how much time will be required for questioning. Tomorrow we'll be hearing evidence from Mr. Masters in Soils and Mr. Shovelton in Agronomy. So if parties would like to ask questions of those witnesses, they'll need to advise Planning Panels Victoria of that by 3 p.m. today. And I understand we've received advice from one submitter. The time allocated to mine-free Mallee Farms at the hearing. Dr. Shove, we note that the client isn't calling as many experts as originally intended, and I'm wondering whether there might be any scope to review the allocation of time that's been allocated or to modify the timetable to take that into account. I assume you're still going to use the vast bulk of the time that's been allocated, but there's one day that I'll just bring to your attention, and that's Monday the 15th, where we're hearing the evidence of Mr. Hewson. And I think we've allocated the entire day for that. I'm just wondering if you could perhaps review that and advise us whether you think you'll still need the full day or whether a half a day would suffice, given that we've generally been proceeding on the basis that most experts can be dealt with in a day. I'm asking because if we only need to sit in the afternoon, for example, then it means that we can come up in the morning rather than the Sunday beforehand. Happy for you to review that and any other elements of how your case has been timetabled, and if you can suggest any efficiency gains for us, that'd be appreciated.
Thank you very much. I'll get some instructions on that, and if we can create some efficiencies, we certainly will seek to do that. On that issue, though, I did want to raise when mine-free Mallee Farms opens. I'd anticipated, we're just seeking clarification that we would officially open after the proponent gives its evidence. I say that because I know that we're interposing some witnesses, I think because of witness availability, but just wanted to make it the clarification around.
Well, typically what happens, and this is the way that we've addressed it or proposed it in the timetable, is that we'll hear from the proponent, then we'll hear from government agencies and councils, and then we'll go into the submitters. And from memory, you're the first of the submitters.
Thank you.
So we're proceeding on that basis.
Thank you.
Now, they were the only matters that we needed to raise. Ms. Porter, you had some preliminary matters?
I think I'm now down to one, and that's merely to update you on the conclaves. I think you might already have a decent appreciation of where we're up to anyway. You would have appreciated that conclaves have been held in air quality, and that's been tabled as document 105, noise and vibration document 104, and radiation and human health 103. We understand that soil and rehabilitation or agriculture, there's been a conclave held already, and there is a report prepared. I think the only thing we're waiting on is a signature from Mr. Sonigan, who I think was on a period of leave. So I think we're expecting that to come through today, and so hopefully we'll be able to upload that tonight. Obviously, that would be ideal, given that tomorrow is when those witnesses are giving their evidence. And then the final conclave was in the area of groundwater, and I understand that's occurring today, as has already been foreshadowed.
Okay.
I think everything else has been covered off already.
Mr. Chairman, can I just flag?
Yes.
In response to that, if the conclave isn't signed and uploaded tonight, then how will we proceed with evidence on Tuesday, and I ask this because obviously I need to ensure I've prepared appropriate cross-examination. So if that's not going ahead, is the proposal, for example, say to call Dr. McAllister Florum for evidence first, or how's it proposed to be dealt with, or is it a case of calling the evidence and not having the conclave, which would.
I understand there is a report. Everyone's agreed on it. We're just waiting on a signature. So I'm really hopeful we'll have it today. It's not in our camp. It's Mr. Sonigan's signature we're waiting for. So.
Okay, and how do we proceed if we don't have the signature?
I'm not sure why we can't have a signature, or even just an email to say, even though I can't apply my signature, I've read the report and it's fine, or something like that.
Yep.
Then we can file it. So I'm not sure that we need to concern ourselves with it if it's not going to be an issue. I have every anticipation it'll be circulated today. If it's not circulated today, I feel like we need to cross that bridge if we get to it. I'm not in a position where I can switch around witnesses because my witnesses have been locked into their dates. I don't imagine it being a problem though, because we can get them to confirm through their evidence what was agreed or disagreed. It's obviously messier. I'm hopeful that we get the signature today, or an email saying I've read the report and it's fine.
And in the event that we can't get either of those, is it possible to table the document without that signature?
We would be happy to if there was no objection to that being done. It might have to be on the proviso that we don't have Mr. Sonigan's signature, we don't have Mr. Sonigan saying he's comfortable with it, so we'll have to proceed on that basis.
That would be acceptable from the EPA's perspective.
Not ideal, obviously. It would be great if it was all signed, but in order to keep the hearing progressing, I think if that was the last resort, then we might rely on that. But certainly we'd encourage, obviously, everyone to try and get Mr. Sonigan's signature.
Through you, Mr. Chairman, if there's anything that Ms. Tannick can do to hurry that process along, we'd be very grateful, but appreciating it's a third party who's not here today, so I don't want to be speaking on his behalf.
Okay, well, we'll proceed on that basis. Thanks. Are there any other matters from the EPA? That was the other one you raised.
I have a brief thing in relation to the site inspection. Were we going to discuss that in any further detail?
I suspect we are now.
Do you know what? It's actually, I think it's a non-issue. It's something I'll just speak to the proponent over the break. It's really a non-issue, and I don't think it's something that the IAC needs to turn its mind to. That's fine. It's just whether one or two EPA people will be there.
What is if we've run out of capacity on the bus?
It would be fewer rather than more, so I won't take your time with that.
I'll keep out of that, thanks. Dr. Sharp, any preliminary matters from your client?
No further preliminary matters. Thank you very much.
Were there any other preliminary matters anyone wanted to raise?
Ms. Easton has one. Yep.
Mr. Eastman?
Yeah, thank you very much for that. I wrote a letter to the committee, table document 25, which expressed a lot of my concerns when I was trying to do my responses to the EES. I'm assuming that people would have read that. It's a fairly important email. And there's a few things around that I'd like to raise, but what strikes me most of all is that a lot of these matters would have been dealt with had the TRG been doing the job that the public might expect of it. Because
Mr. Eastman, I think you're making submissions that you might want to make in the course of the hearing when you make your submission to us.
To an extent, yes.
If I can just finish, I'm not sure that this is a preliminary matter.
It is a preliminary. Sorry, can I just continue with, because you said to bring them up in the preliminary matters. So one of them was the development licence application, which you said I could bring up in the preliminary matters. My not knowing why, or trying to find out why only the sewerage and power plants are used in the development licence application when it's such an intense process otherwise. Why aren't all the other infrastructure things, including the flotation and hydromet plants, included in that. The other one was concerns about the failure to do the geochemical analysis of their stockpiles, particularly the overburden ones, and even the responses that the proponents put out hasn't referred to overburden or HMC stockpiles, and it's really important to get a good look at those for the size of the particles, because that determines how far they're going to blow and what they're going to impact on. Sorry, just I have a question too. The proponent said that Invest Victoria was involved in the technical reference group, and I'm just wondering what role they might have played in that, and whether that's influenced some of the stuff that's come out, or the rush to get this through without all the information the public needs to make.
So you've got a question about whether Invest Victoria was involved in the TRG, is that?
Yeah, proponents Part A submission said that they were.
Ms. Porter, can you confirm that?
I'll have to take instructions. I don't know.
So my biggest concern is about the chemistry of the process, and the proponents, I think it's TD 93, gives information about the chemicals that are being used. I was concerned that the RFI didn't ask for more information about the chemicals being used. You did ask for how they were going to be stored, but there's nothing in there giving any information about how they interact with different things and how they're going to interact when they're commingled in tailings. The proponent in that, I think it's TD 93, sorry, apologies if it's not, mentions 4 places where this acid bake process are being used. The only one where it's currently being used, the proponent notes, is Bateau in China, which is part of the, they call it the sacrifice zone, and it's one with all the cancer villages, because the tailings have been allowed to go into the groundwater and then to the Yellow River. The other sites that the proponent refers to actually use linings on their tailings dams and don't dump tailings straight into the pits. And I guess that goes back to another question that I have. Can you clarify who actually has responsibility for regulating in-pit tailings? There seems to be a bit of disagreement as to whether it's Earth Resources or Environment Protection Authority.
Well, I think the best way to respond to that is to note it as an issue that the proponent will no doubt address either through the course of the hearing or in its closing submission. We can't deal with it now. Are there any other preliminary matters that you wanted to raise?
No, not just yet, just that my concerns, it seems to be a build your own adventure thing, and we're finding out as we go about this rather than having been presented properly in the ears to start with. Thank you.
Okay, thanks, Ms. Eastman. Ms. Carruthers. Ms. Carruthers, you're with us?
Yes, I am. Thank you very much, Mr. Chair. My matter relates to preliminary matters I was given an opportunity to raise today, and that's, as you gave in your introduction, in response to TD 36, and that was in response to the proponent's TD 15. And I raised new themes in TD 36, and the proponent has indicated that those themes are considered as part of other themes in that TD 15, and I dispute that. Just to clarify, the new themes were around agriculture, a threat to pre-existing long-term sustainable jobs, both direct and indirect in agriculture. The proponent claimed that that was covered in theme number 2, which is loss of prime agricultural land, or in theme 3, impacts on farming practices. Now, I very strongly suggest that threats to existing jobs are not in either theme 2 or 3. And this is an important consideration, and I'll say why that is in a moment. And the other theme is in relation to economics, And my theme point was the threat to jobs and the significant long-term economic contribution of agricultural industries here. And the proponent claimed that that was covered in theme 25, which was business disruption, or theme 26, which was future production and income from farmland, or theme 27, competition for labor and increased cost of wages. Threats to the economic viability and contribution of agricultural industries in the area are not, in my view, covered by any of those themes that the proponent claimed. The reason why this is important is that the impact on existing jobs, both direct and indirect, and the threat of loss of income from the agricultural industries are significant environmental effects. And indeed, in the Fingerboard's EES process, they were recognized as unacceptable environmental effects. And so my argument is that that these are themes that should be picked up in that document, and that the potential loss of more jobs could be generated. So there's a potential loss of more jobs that could occur as a result of this project than what would arise from jobs that could be created, are the points that I'd like
Ms. Crothers, if I can just stop you there for a moment.
I'm finished.
This isn't a preliminary matter, this is a submission, and we're looking forward to hearing your submission during the hearing. Can I just reiterate a point that I made earlier? The starting point for the committee is to consider the written submissions, including your written submission that were lodged during the course of the exhibition of the EES. We don't rely exclusively or solely on the summary of themes provided by the proponent. It's a useful document. It's not intended to catch every issue and every matter of concern to people. It's really a very higher order overview of general themes. We're satisfied with what's been presented to us. We acknowledge the proponents made some changes. They may not address everyone's concerns, but we're satisfied, given the limited role that that document has, that it's adequate for our purposes. But if I can just reassure all submitters that our starting point is really to go back to all of the written submissions that were initially lodged, and then any additional material that submitters provide if they're making a submission to us during the hearing itself.
Thank you for the opportunity to speak.
Okay, thanks, Ms. Crothers. Were there any other preliminary matters?
Sorry,
Mr.
Mr.
Bergen.
Chair, and this, I should have raised this at the corrections hearing, so apologies. Just following on council, just like to reserve the opportunity to provide closing submissions.
I think we did discuss that at the directions hearing. I think, in fact, you did raise it, and we haven't timetabled that. But if, as the hearing progresses, that you feel that there are matters that you would like to respond to, then I think we can do that at the end of the hearing. Okay, thanks. Any other preliminary matters? No? Okay, that's a record for me, an hour for preliminary matters. We'll push on the timetable. We're hoping to hear from the proponent with a brief opening submission before we then hear from the Impact Assessment Unit and then the EPA.
Mr. Chairman, if it is particularly given we're a little bit delayed on the timetable, we only had 30 minutes and then we're coming back to you after lunch. What I can do now is just quickly give you a roadmap of the documents that we've provided and where we're headed to once I do open after lunch, and then allow the other parties to make their opening submissions. Otherwise, it's going to be a bit disjunctive. So if you're happy for me to do that, I can very quickly step you through that. As the committee and the parties would be aware, we filed in compliance with the directions a substantial Part A submission, and part of my opening today will touch on some aspects of that submission, but we're otherwise assuming that that's been read. We also tabled a brief Part B submission, and then we filed a number of what we'll probably be calling the day one documents, and that is the environmental management framework that's been amended to some extent to pick up recommendations of experts and following submissions. We are in the process of preparing a document that reconciles where expert witness recommendations have been made and picked up in that document and where they haven't, and if not, why not? And so that is a work in progress. I think that'll assist you in understanding where we got to with the day one. I think it's also fair to say, though, that the day one, there's always a bit of a journey that the EMF goes on in these proceedings. We haven't yet heard all of the evidence and heard it be tested. And so there will no doubt be refinement to that, and that will result in us issuing what we'll call a day two or a part C EMF. With the day one documents, we also provided a day one version of the explanatory report and incorporated document for amendment GC 218. With both the EMF and the incorporated document, Mr. Forrester will step you through the day one changes in a little bit more detail this afternoon. And as I've said, we'll be filing a day two or a part C set at the close of all of the evidence. We've also filed a response to the council planning scheme recommendations. I think it was Swan Hill Rural City Council submissions and recommendations, and we've filed a table that sets out our response at this stage to those recommendations. We've filed our response to the themes raised in submissions, appreciating that not everyone's content with the way in which we've summarised the themes, but that's where we got to. We would say that, as you've already said, that the committee has to consider all submissions in any event, and we'll have to be responsive to those submissions regardless of how we've chopped and cut them up in a summary form. We've also provided a table of our responses to date to the RFIs, appreciating that there's more work to do on a number of them. And then following that, we also provided technical note 1, which is the fate of the flocculent in groundwater in response to RFI 59. And we've subsequently provided the material safety data sheets in response to RFI 48E, which you will see. After lunch, when I open the case, we'll also go to the filed presentations of VHM's CEO, Mr. Ron Douglas. He's going to do a short presentation, basically just explaining who VHM is and some brief matters that are contained in slides that he's provided. And then we'll also have a presentation of Mr. Gavin Williams and Mr. Gavin Beer. They are the consultant metallurgists in this project, and they are going to give you a much more technical presentation than I could achieve of the project's, particularly the processing components of the mine. So that'll be after lunch again, and that'll be in compliance with the slides that they've already tabled. So this afternoon I'll open the case. I'll ask Mr. Douglas, Mr. Williams and Mr. Beer to present their material at the appropriate time. I'll ask Mr. Forrester to step you through the day one documents at the appropriate time. And I'll be intending to address the nature of the committee's task in this proceeding, the policy setting and the approvals framework, and one or two specific matters. That's what I hope to achieve this afternoon, and hopefully it will be a useful exercise and not take up too much time repeating material that's already been filed. That's all I wanted to say by way of very brief summary overview.
Okay, thank you. Can I just note that I was actually going to raise with you at some stage today or tomorrow the usefulness of having a document that explains where the changes to the day one EMF were derived and why some were accepted, some not accepted, or as you've outlined. So
yeah, that's pretty much the work in process, and I agree that would be a very useful exercise for everyone.
So, thanks for that. Now, in terms of the presentations that you've scheduled for this afternoon, I understand there's been some documents that have been submitted to us, some PowerPoints or something of that nature. I just haven't had a chance to check on what we've received.
Yes, so 3 documents came in with our day one documents, and that was the presentation of Mr. Douglas on what VHM is.
I was just understanding there were some that may have been sent this morning.
The one that was sent this morning, it's literally just a PDF that has the documents that I want to go to in opening, but collated into one spot so that I'm not jumping around a whole lot of documents. And so, yes, I think that was filed either last night or this morning. I think it's in the order of 23 slides, and it's literally just material taken from either the EES or Part A submission, and it's hyperlinked documents.
Okay, I just wanted to make
It's
sure.
really to make sure it's an efficient process rather than me jumping around a whole lot of documents.
Okay, great, thank you.
I think it's fair to say you don't need to be across it before I present. I'll step you through it.
Thanks. We were going to hear next from the impact assessment unit. I'm just wondering if we might take a short break now before we hear from you, if that's
Okay, it's I won't be particularly long, but
How long?
I'm probably 5 to 10 minutes max.
Okay, we're happy to hear from you now.
Okay.
Been there for you.
Thank you, Mr. Chair. As I advised before, I'm a senior impact assessor in the impact assessment unit within the Department of Transport and Planning. The impact assessment unit administers the ES process on behalf of the Minister of Planning, along with Rob Pickenen and Glenn Murray. I've led management of the ES process for the Goschen Mineral Sands project under the Environment Effects Act in accordance with the ministerial guidelines and procedures and requirements issued for this ES. I've prepared a written statement which was supplied to the IAC last week and has been published on the Engage Victoria website for the Goschen Mineral Sands project. IAC is document number 85. I do not propose to read the whole statement supplied. It is available to everyone, but I'd like to take this opportunity to highlight a few points. This statement is made on behalf of DTP's Impact Assessment Unit that is solely contextual. It's not made in relation to the merits of the project, the ES itself, or the predicted effects, or the substance of the submissions made by any party. It is provided to give a background on the ES process and to set out relevant matters for the inquiry and submitters to understand about the process undertaken to date. We will be in receipt of the IAC's report in due course and will be responsible for advising on the Minister's assessment of the project's effects that will be issued under the Environment Effects Act at the conclusion of the ES process. The Minister's assessment will inform decisions on the project. In October 2018, the Minister for Planning determined under the Environment Effects Act that an ES was required for the Goschen Mineral Sands and Rare Earths project due to its potential for significant effects on the environment. The project was also determined to be a controlled action under the Commonwealth Environment Protection and Biodiversity Conservation Act, or the EPBC Act, because of its potential for significant impacts on matters of national environmental significance, such as listed threatened species and communities, Ramsar wetlands, and nuclear actions. The ES process is accredited to assess impacts on matters of national environmental significance under the EPBC Act through the bilateral assessment agreement between the Commonwealth and the State of Victoria. The Minister for Planning's assessment under the Environment Effects Act will inform the Commonwealth Minister's decision on whether to grant approval of the project under the EPBC Act. The key stages of the ES process have been managed by the Impact Assessment Unit from Department of Transport and Planning and are as follows. The Technical Reference Group was established to advise on the scoping and adequacy of the ES studies and the ES documentation, including the draft planning scheme amendment, as well as interface with approvals that would be required for the project to proceed. ES scoping requirements were drafted outlining the scope of the Goschen Mineral Sands and Rare Earths project and its informing technical studies. These scoping requirements reviewed by the Technical Reference Group, publicly exhibited and then finalised in May 2019 in light of the submissions received. Draft ES documents and draft planning scheme amendment documents were prepared by the proponent and their consultants and were progressively reviewed by the Technical Reference Group. Technical Reference Group met on 8 occasions between February 2019 and September 2022 to discuss issues relevant to the Goschen Mineral Sands and Rare Earths project. The ES documents were then finalised and exhibited for public comment from the 20th of November 2023 to the 17th of January 2024. The completion of the public hearing process, the IAC will prepare a report on their findings and recommendations on the likely effects of the project as per the terms of reference. The final stage of the ES process will then be for the Minister of Planning to issue an assessment of the effects of the project to inform statutory decision making for the project, in particular under the Mineral Resources Sustainable Development Act and the Environment Protection Act. The Minister's assessment must be considered by Victorian statutory decision makers and by the Commonwealth Minister of the Environment. Given the multiple approval decisions that the Minister's assessment must inform, it'd be very helpful to DTP's Impact Assessment Unit in terms of advising the Minister about her assessment. If the IAC can frame its report and in particular its recommendations with links to approval decisions and controls that are relevant to the project. Thank you, Chair. I'll be happy to take any questions that you have before that.
Thank you. Mr. McIntosh.
No question.
Ms. Bell, do you have any questions? Just one from me, and it's not particularly significant. It's really just I suppose, an administrative question. In document 85, you refer in the first page to the published reasons for the EES decision, and you've quoted some A through to H. I'm just the document that I had been referred to in terms of the published decision, and this isn't a table document, but it's freely available on the internet. And it's the date of decision of the 10th of October 2018 that I'm sure you're familiar with.
Okay. So you're saying the date of the procedures and requirements are different?
No, I'm saying that the reasons for decision are different. I'm just for the parties, that's the document that I'm referring to, which is readily available on the internet. If you just do the search for Minister's decision for Goschen. I'm not sure it's a table. It's not a table document. I'm not sure if it's part of the EES background material. I'm just going to
Yep, no problems.
provide Mr. Pearce with a copy of it. So that specifies some reasons for decision there, and they're different to those that you referred to in your submission to us, which are drawn, as I read it, from the scoping requirements.
So I believe those points A to H are from the statement of decision, not from the reasons of decision. So it's probably, I have to go through the submission and maybe it's poorly worded.
Happy for you to take it on notice. And I don't think anything significant hangs on this, but we would obviously make reference to the reasons for the decision in our report as part of the background information. I just want to make sure that we're referring to the right material. If I can just grab that.
Yeah, for sure.
Thank you. So it's really that's the document we understand is the reason for decision. If you can confirm that.
There was a statement. There's usually a statement of decision and a reasons for decision, and so it potentially is poorly worded, but I'll get back to you definitely on that one.
Right, thank you. I think we might take a coffee break now before we hear from the EPA. We'll take 15 minutes. Thanks, everyone.
If I'm not around.
Or,
You know, like,
sure, okay. I assume, but all others.
depending on what's left
Yeah.
and.
I
but as a
assume
general-
hydrology is wanting to given.
Yes.
Enthusiastic to get started.
So yeah, that sounds good. You can just confirm when you get the chance.
Thanks, everyone. Just before we hear from the EPA, can I just note that in terms of cross-examination of tomorrow's experts, we've received advice from the EPA that they'll be seeking for 45 to 60 minutes for Mr Masters and 30 minutes for Mr Shuttleton. And we've also received advice from Mr Bennett, Mr Bradley Bennett, that he will be asking 10 minutes of each of the experts.
I can also give a brief update. Apparently, Mr Sonigan is attending to the conclave report now, so there should be no issue with having that report filed as soon as it's made available before tomorrow.
Okay, thank you. If there are no other matters, hear from the EPA.
Thank you. The EPA's opening submission, you'll find at tabled document 106. So the EPA is an independent statutory authority, and its objective is to protect human health and the environment by reducing the harmful effects of pollution and waste. It exercises its powers and performs its functions for the purpose of achieving that objective. And so the EPA's submissions and concerns throughout this IAC hearing process are tied closely to those duties and powers and functions. It has a dual role, firstly as a submitter participating in this hearing, and secondly as a decision maker considering evidence and submissions that relate to the development licence application. I wanted to note, just draw your attention to paragraph 9, where we note that the EPA is not calling any evidence for this hearing and that it's common for the EPA not to call evidence during the IAC hearings. In terms of after the hearing, if the Minister determines the environmental effects of the projects are acceptable, EPA will continue to be involved in the following key respects. It will have consultation roles. So, for example, the Earth's resource regulator will typically refer a work plan to the EPA to have its comments on it, but it's not a decision maker in relation to those work plans. The EPA will be a decision maker in relation to the development licence applications that have been advertised and the A18 permit application and operating licence applications. Now, those permit applications and operating licence applications aren't before the IAC, and I've gone into that in some detail in the submissions about the reasons for that, but essentially it's the development licence were required to be advertised as part of this joint process. The EPA also has general regulatory and enforcement roles consistent with its obligation under the legislation. So promoting, monitoring and enforcing compliance with the EP Act. So obviously a key component of that will be the ongoing responsibilities around the general environmental duty at section 25 of the Environmental Protection Act. I wanted to draw the committee's attention at paragraph 12 to our submission 147. That is going to be something that will assist you greatly, we hope, in the preparation of your report, and has a lot of detail, and we certainly, I understand that you've had the opportunity to look over it, but I'll certainly endeavour in my submissions to point where there's further information that's relevant where it is, and I'll try not to regurgitate that information any more than I have to, and really focus from here on where are we at now and what are the ongoing issues. The EPA made 44 recommendations in relation to the exhibited material, and later in the submissions I've really set out and grouped those under relevant subjects headings, so it's easy for everyone to turn their minds to what they're about and whether they've been addressed sufficiently so far. In terms of the expert evidence, a number of EPA's recommendations have been supported by the experts. Where EPA's recommendations have not been accepted or alternative recommendations are proposed, EPA will engage through this hearing process to better understand the basis for that. following consideration of the relevant evidence, including evidence given under cross-examination, together with consideration of relevant submissions, technical notes and other documents submitted to the IAC, EPA will consider whether it continues to press for those outstanding recommendations or whether the alternatives are available to it. This opening submission is based on the EES as exhibited, EPA's submission 147 and the written expert evidence. These submissions, and this is in accordance with EPA processes and its need to consider materials and go through its internal administrative processes. The submissions were finalised prior to any joint conclave statements being filed and prior to the EPA undertaking a fulsome consideration of the day one package. So really, by and large, these submissions don't intend to engage with those materials, and that's something that will occur as part of EPA's submissions on day 9. In line with its independent statutory role, EPA reserves the right to raise further matters of concern outside of those identified in submission 147. And certainly I've endeavoured to draw some attention to matters that have come into some more focus as a result of submissions filed in response to the exhibition, the EES, or matters that have arisen through expert evidence. And of course, that will be a focus of my main submission moving forward, and a submission and on any subsequent matters on the final day of the hearing. At page 5 from paragraph 17 onwards, I outline the EPA permissions framework, and I understand the IAC is really quite likely to be very familiar with this, so I don't intend to go in huge details to that. But I'm also aware there are a number of community submitters listening in today, and that they'll be interested to note, and also relevant to the committee, that the EPA is the primary regulator of discharges to surface water and groundwater from mining and quarrying industries. So when we have a mine, it's a different situation from certain other activities that the EPA has responsibilities for, where it may also be the primary regulator in relation, for example, to noise emissions and the like. The EPA is responsible for advising on monitoring of air quality and noise emissions, and has responsibility when responding to referrals for mining from other government agencies such as the EIR. And again, that's consistent with what I outlined earlier of the EPA typically being asked to provide some comment on work plans, but it being a very different role from its usual role in activities. Of course, it's important to keep in mind that it is the EIR that is the primary regulator for mining and quarrying, as per the regulatory functions under the Mineral Resources Sustainable Development Act 1990. And obviously they're not present as part of this, they haven't elected to be part of this IAC hearing process. EPA permission is not required for discharges, emissions or deposits to the atmosphere or land that are in accordance with the MRSD Act, whereas permission is required for discharges to surface water and groundwater. There are no proposed discharges to surface water for the project. The proposed seepage of the tailings leachate to groundwater will trigger a requirement for a permit pursuant to activity A18, and that's discharge or deposit of waste and aquifer. Unlike an application for the development licence, applications for permits are not required to be advertised as part of the EES process. And we observe here that the proponent has chosen not to exhibit an A18 or draft 18 permit application as part of the documents exhibited with the EES. In terms of the development licence application, I wanted to draw your attention to paragraphs 25. The activity of the subject of the development licence application is an activity to the Environmental Effects Act applies, and notice was combined with the EES. EPA is in the relatively early stages of that assessment process, and given this, the EPA reserves itself from statements of support, recommendation or requirements in relation to that application. Any submissions the EPA makes to the IAC related to the development licence application should be understood as preliminary observations, which may change as EPA undertakes more detailed assessment of relevant materials. And no part of this submission should be relied on by any person as being indicative of EPA's final decision regarding whether a development licence or any other statutory authorisation will or will not be issued in respect of the project. What follows shortly after that in my submissions is the identification of the issues around the alternative pipeline route, and the question, and to note that EPA is paying close attention to that. And similarly, so I'll leave that for you to read and consider in your own time, and we look forward to seeing the additional information and learning the proponent's position as to its preferred route. Finally, I want to touch upon really what EPA sees as the key issues for the forthcoming IAC hearing on the basis of the material to date. Obviously, submission 147 is a very, very detailed analysis of the EPA's concerns in relation to the exhibited documents, and this was put the proponent on notice of what EPA, as the environmental regulator, saw as the key issues relevant to its powers and duties. That course of action has provided an opportunity for the experts to consider EPA's recommendations prior to this hearing. The EPA appreciates the clear way in which some of the experts have responded specifically to its recommendations. EPA is assisted by experts that specifically accept or reject its recommendations or provide an alternative for EPA to consider with reasons as to why the alternative is presented. And certainly I would encourage experts to always engage with the EPA on its recommendations, whether they support them, or if they don't support them, giving reasons why. And it certainly helps when that's stated in a very clear way, ideally where they can by reference to the actual recommendation numbers. And that's an approach that some experts have taken, and certainly just wanted to have on record how helpful and efficient we found that to be. And obviously, if we can focus on the matters that really matter, that uses everyone's time and the committee's time in the best way it can be. And we believe it's the best outcome for the environment to really work out what is it that we're uncertain about, it, what needs to be fixed, and where are we at with all of this. At paragraph 42, I just wanted to raise the issue of the kiln that is part of the HydroNet process. The information about that was very light on in the EES, and I've referred to chapter 3 where it's mentioned. That's at the PDF 24 of chapter 3 in footnote 21. Obviously, there's been some additional material filed with the day one materials. EPA is considering that information, and it's really looking to ensure the process is fully described, that all anticipated risks to human health or the environment from pollution or waste have been identified and eliminated, or where not able to be eliminated have been minimised as far as reasonably practicable. That mitigation measures are proposed to reduce potential risks are sufficient, and that's obviously where they are proposed. the relevant approval and permissions regime has been appropriately identified, and it's clear whether permissions are required for the IAC process or at a later stage. For example, is a separate permission under the EPA Act required for discharge to atmosphere, or is it within the exemption that pertains to mining works in accordance with works plans? And really looking to the proponent to provide that information in a nice, clear manner so that the EPA can assess that response and consider its position in relation to that, and ensure that all of the necessary approvals have been considered, all of the exemptions have been. The EPA will be turning its mind to if permissions under the Environmental Protection Act are not required, is the information currently before the IAC sufficient? And obviously having a focus on the terms of reference for the hearing. If EPA permission is not required, it doesn't have the same legislative triggers to refer. So, for example, in the case of the development licence, it has powers under the Environment Protection Act to issue requests for further information to the proponent, and that way it can address information gaps. If it doesn't have those, if there isn't a permission required, then it doesn't have those triggers and powers. And in terms of the amendments to the MRSD Act, those changes are due to take effect on a date to be proclaimed or in the absence of a proclamation on the 1st of July 2027. The proponent, of course, in its Part A submissions indicated the Amendment Act may influence how any condition that the IAC considers should be imposed are implemented. The EPA submission, further clarity on the consequences of the amendments to the MRSD Act is necessary, and we encourage the proponent to address this in greater detail well in advance of EPA's submissions on day 9 so that the EPA can consider and respond. Obviously, if that doesn't occur, the EPA does have the opportunity in close to refer to things that have arisen during the course of the hearing. The EPA submits that the IAC will need to be confident that once work plans are abolished, there are means by which the requirements in the EMF can be enforced. May be necessary for the IAC to make recommendations in this respect. What follows in the submissions is a breakdown of the specific recommendations and a heading to sort of group the themes. So the first 2 recommendations deal with the environmental management framework. I wanted to note here that the proponent's Part A submissions state, Chapter 21 of the EES is the environmental management framework, proposed to be given effect through conditions on relevant approvals. Now I note here the day 1 response, which obviously to the IAC's RFI at question 100, and that's tabled document 94. And that this isn't, noted in my submissions because it wasn't part of the materials responded to. Now, I won't respond to what the proponent puts in that position there, but obviously its position there, it's something we'll deal with as part of our main submission. Certainly aware of it being an issue that we think the committee needs to be engaged with and that we'll be seeking to assist you on. Again, the EPA is turning its mind to whether how everyone can be confident that what it says it's going to do is in fact what it's going to do and that it can be held to account. To making sure that is it the case that all aspects of the EMF can be equally enforceable? Is it the case that the mitigation measures at table 21-5 and Table 21 and the monitoring and contingency measures at 21-7 will be enforceable, and how they'll be given effect, and how that we know that those particular measures, which we've had the opportunity to have feedback on and give submissions on, are the measures that will appear in an enforceable form at a later stage, because obviously this is the chance for the public to have its say and to grapple with those things, and to be in a position to make submissions about what it says is appropriate or not appropriate. Recommendations 3 to 8 involved groundwater measures. Now, we say Mr. Fawcett has not clearly responded to the specific recommendations of the EPAs and whether he agrees or disagrees with EPA's recommendations. Obviously, it's not a requirement that he do so, but it's certainly beneficial to understanding where the disputes may or may not arise. Groundwater has been a key issue for the EPA throughout its involvement, and it's something and the EPA has had regard to the evidence of Dr. Macumber filed by Mine Free Mallee Farms, and that's raised some additional matters. So EPA is paying close attention to the evidence of all of the parties that pertain to these risks with that groundwater, and including the evidence adduced through cross-examination. We say groundwater is a matter that is essential to ensuring the IAC is in a position to report on the environmental effects to whether it's an acceptable environmental outcomes can be achieved. Obviously, that's a key matter for you in terms of your report and the terms of references at 38A and B. EPA recommendation 3 called for a revised groundwater risk assessment to address the uncertainties and assumptions in the groundwater risk assessment in terms of geochemical processes and the contaminants of potential concern in tailings seepage. EPA also has concerns about hydrogeological conceptualizations and the associated uncertainties and assumptions. Obviously, Dr. Macumber's evidence goes into detail as to why he says the assumptions in relation to the hydrogeological conceptualisation are incorrect. And that's a matter that the EPA is taking very seriously. It's something we would presume the proponent will be looking to respond to and engage with as part of its process in the hearing moving forward. We note that Mr. Fawcett's evidence at Annexure A did contain a revised groundwater risk assessment. EPA is considering that response, but at this point, its concerns are not resolved. Contamination, and I wanted to include paragraphs 57 and the following unnumbered paragraph in the submissions to just make it really clear before we hear the proponent's evidence that contamination of groundwater is extremely difficult and costly to remediate. EPA strongly recommends appropriate steps be taken to ensure that groundwater is not contaminated in the first place, given the difficulties of remediation. The EPA has extensive experience of dealing with groundwater issues and remediation difficulties. The EPA's experience is it's far more cost effective and practical to undertake some additional testing, some additional research and investigations at the design stage aimed at preventing contamination of groundwater in the first place, rather than implementing contingency measures once contamination has occurred. This accords with Sections 18, the Principle of Waste Management Hierarchy, and Section 25(4) of the Environmental Protection Act, the General Environmental Duty. So we really want, and this is really the reason why there is such focus on groundwater and the level of confidence we can have in that assessment. And if there isn't a sufficient level of confidence, the need to go and do some further work to get that sufficient level of confidence, because it is just so difficult to fix and address pollution in groundwater once it's made its way there. EPA's recommendations 9 to 13 dealt with soil issues. I just wanted to note here at paragraph 59, although EPA's recommendation pertaining to soil stripping has been addressed, or at least partly addressed in the evidence and I note subsequently in the day one EMFs, a number of its recommendations have only been partially addressed or not at all addressed by the experts. Again, EPA is looking at how there are looking at how the proponent is resolving the recommendations of its expert and how it got to its position, and it certainly will also be assisted by the documentation that Ms. Porter outlined as being prepared. In terms of noise, that EPA recommendations 14 to 25 are dealt with in noise, and on the basis of the expert witness statements, the issues in dispute are limited to matters around adopting the quietest available process and plan. And it's hopeful that we can resolve that one and take it off the table, but we're not quite there yet. In terms of the issues around natural areas and whether something is identified as a natural area or not, and whether that has been properly considered and assessed at this stage of the EES, and if it hasn't, what further needs to be done. And then recommendation 25, which is around noise from off-site truck movements. In terms of surface water, that was recommendations 26 to 32. And at paragraph 72, you'll see Mr. Moon proposed alternative wording for EPA's recommendation 29, and recommendation 29 was directed to the issue of whether the active pit dimensions are of sufficient capacity to ensure runoff generated in rainfall events greater than 5% AEP. So obviously the proposal for this project is that stormwater will stay on site and be captured in various ponds around the mine site, but if up to, and they've been sized to allow for an event up to 5% AEP. But if there is rainfall that's heavier than that, greater than that, then the overflow will be directed into the active mine pits. An alternative mitigation measure was put forward by Mr. Moon, and it states at all times during operations the mine void will be designed and constructed to ensure capacity to capture runoff generated from active areas in rainfall events up to the 1% AEP 72-hour design storm event, including allowance for climate change and at least 0.5 metre freeboard. And we just wanted to note that we have considered that alternative recommendation and that it is acceptable to the EPA, that gives the EPA, and obviously the IAC will make its own decision, confidence that the risk has been suitably minimised. And we're certainly looking to engage with trying to resolve matters in the way that we have here and making that clear to the IAC. There are a number of matters that have yet to be clearly resolved, and which require further clarification. And I don't propose to go through what they are now. No, the shortage of time. In terms of recommendations 33 to 39, they relate to air quality matters, and it would appear that it's only recommendations 33 and 34 that are outstanding. That's around the need to minimise dust impacts by having a tiered, the EPA seeking the tiered vehicle speed. There may be some other matters being ironed out in relation to the two of them, but that seems to be the key outstanding matter in relation to air quality. In human health, I note that the EPA's recommendation that there be testing of domestic rainwater tanks has been picked up with a new mitigation amendment. The EPA is still working to make sure that is a sufficiently robust mitigation measure, and that we think that the EPA position is that it's appropriate at this stage that should list what's the chemicals and elements that are being tested, and in particular the EPA is calling for speciation of the chromium to understand whether it's chromium 3 or chromium 6, and to be able to assess the risks associated with that. And finally, there were 4 recommendations made in relation to the planning scheme amendment. So in conclusion, the key issues that have arisen since the EES were exhibited pertain to groundwater and the competing views of Dr. Fawcett and Dr. Macumber. In terms of the remaining areas, we're still going through the process of assessing the extent to which there are outstanding recommendations, and we'll be looking to ensure that there are sufficiently robust and clearly drafted mitigation measures in place that are enforceable. The IAC, the EPA will be involved throughout this hearing, at times by myself, at times by other members, and we certainly invite the IAC to reach out to us if there's specific questions it has or things that it needs addressed. There are my submissions in opening. Are there any questions?
Thanks, Ms. Armstrong. Mr. McIntosh, do you have any questions?
I do, thank you. So it's a couple of points of clarification. You refer to in your paragraph 10B, VA 18, which is the category for discharge to groundwater, and that's subject to a permit. You're not looking for any recommendations in regard to permit assessments or issues within the EES?
Not at this stage, and the reason for that is that the permit isn't before us with the EES. Obviously, again, if as part of listening to the submissions that are made and the evidence that comes out, that position changes, then that's something the EPA will be in a position to raise and put. But I appreciate the question that you've raised, and take it on notice for the EPA to consider in some further detail.
Well, it's a part A and B question. B to that is your paragraph 18, where you say that EPA is the primary agency for groundwater. So therefore that needs to be a consideration of concern, some concern to us perhaps. Now, the assessment framework you would expect us to use would be the environment reference standards and environmental values when it comes to groundwater. So it's not making a recommendations or findings perhaps on a permit application that we haven't got before us, but it may be quite right to make comments in regard to impacts on the groundwater environment. I'll put it in those general terms. it's a fairly broad area to cover the groundwater environment for protection like that, but I think we understand. The other issue is a noisy one. The natural areas, or category 5 as we're classified, is there any further advice or guidance that EPA could give to planning authorities or whatever in regard to what areas could be considered? Because that's a broad category within the guidelines there, or the protocol, as to what a natural area is. And there's a number of areas potentially identified that that category could be applied to. So is there any additional guidance that EPA could give as to the thinking of what may or may not be a natural area?
That is a matter that will be addressed in our submissions on, and was aware that needed to be addressed in more detail on our submissions on day 9. I'll turn my mind to the other matters you've raised and whether they can be addressed as well on day 9. I think with groundwater, it may be the case that the EPA needs to take the position that is being taken by the proponent, that the fulsome response to evidence, to some evidence matters, really needs to be put forward once that evidence has been heard. So that might be something that is addressed in terms of the groundwater impacts, is best addressed through the EPA's Part C submission on the final day of the hearing. But I note those issues and matters, and the EPA will look to be responding and engaging with those.
Thank you. No other good questions I had.
Thanks. Ms. Bell,
No, thank you.
no questions?
No, thank you.
Thanks. Thanks, Ms. Armstrong. We don't have any further questions for you. We'll break for lunch now unless there are any other matters we need to deal with, and we'll come back at 1:10 when we'll be hearing from the proponent. Thank you. Okay, thanks everyone. Just a couple of matters from this morning to hear from the proponent. Firstly, the discussion we had about Mr. Fawcett's evidence and the ATC Williams report. Just a couple of observations I'll make firstly. I touched on some of those this morning. Firstly, we note that it's not unusual for new information to be made available before or during a hearing. And we note that the material in the ATC Williams reports really builds on issues and matters that were discussed in the EAS, but takes it clearly to a different level of detail. The evidence report was available from the 7th of March, providing reasonable opportunity for parties to consider and respond to it, including Mr. Macumber in his evidence report. There's an opportunity for the Fawcett evidence report and the ATC Williams report to be reviewed and discussed during today's conclave. There'll be an opportunity to cross-examine Mr. Fawcett at the hearing and to raise issues about the ATC Williams report. And there'll be opportunity for parties to make submissions about Mr. Fawcett's evidence at the hearing. Now, for those reasons, we don't agree to delaying the process or requiring that the ATC report be in some way exhibited. If Mindfree Mallee Farms wants Mr. Macumber or a different expert to review and provide evidence about the ATC Williams report, we'd be happy to facilitate that, but it would need to be provided during the hearing process. The proponent would need to have an opportunity to consider and respond to that evidence, and whoever prepared the report would need to be available for cross-examination. Now, clearly there's some matters that you'll need to think through in terms of whether you want to take advantage of that process or not, and so we won't ask you to respond now, but certainly if you are intending to call an additional expert, then we would be helpful if we could find that out sooner rather than later.
Certainly, I'll need to take instructions on whether we do get another expert. Given that Mr. or I think is it Dr. Fawcett relies on that report of Williams, would it perhaps be of assistance to the Commission to have Mr. Williams available for cross-examination?
Our view is it wouldn't be of assistance at the moment. We can review that, but at the moment we're satisfied with the context within which that information has been provided, and we'll work through how we use it and how we might respond to it.
Thank you. I was also remiss, and my apologies for not pointing out that there are 4 members of Mine Free Mallee Farms here, 4 farmers who have driven up from Swan Hill. Did you want to
Happy
know?
for you to introduce them to us.
Perhaps I could
Put
introduce
some
them.
faces to names.
That's right.
Stuart McCann, Ocean Area.
Thanks for coming. Mr. Kennedy,
Tony Cox from Goschen.
thank you.
Bennett, Albert.
Mr. Bennett,
Thank you very much.
thank you. The second matter was one that I again touched on this morning, and that was in relation to site inspections. And Ms. Salvarage alerted me to a discussion I think she had with yourself or with you, Ms. Danik, about the accompanied inspection only including one privately owned farming property. Now, my recollection is that when we asked for nominations, Mine Free Mallee Farm nominated 2 properties, 2 addresses, the Polars and the Bennetts, and the draft inspection itinerary included drive-bys of both of those properties. Subsequently, we received advice from the Polars or an invitation from the Polars to go onto their property, and so the itinerary was adjusted to take us onto the property rather than just a drive-by. I don't recall that we've received a similar invitation from the Bennetts, and that's why we didn't require the proponent to take us onto the property, but clearly we wanted to drive past it, and we were satisfied that met the conditions of nominating that property, if you like. Now, if on further consideration you're of the view that, or the Bennetts are of the view that it would be helpful for us to go onto their property rather than just drive past it, Mr. Bennett. Yep.
It's on my farm, and more than often have permission to drive on the farm.
And we appreciate that offer, and we're certainly happy to do it. There's unfortunately now you've embarked on a process of having to negotiate with the proponent to allocate times and an itinerary, and they'll be in contact with you to arrange that. Hopefully we can do it on the same day. It may require a little bit of adjustment to the itinerary.
Probably only be 5 minutes to drive in. I've got a track going into my farm and one coming back out.
Well, if it's 5, 10, 15, whatever it is, we appreciate the offer and we'll certainly take you up on it. Thanks.
Could I just add that the poll was nominated, if there's any time to be shed on their visit, they'd be happy to allow that to go down.
I'd rather not cut back on the time that we take on the poll property, because there's quite a few things for us to look at. So it may well be that we have to add some additional time, but a credit to the proponent. They've been helpful in organising all of that, and I'm sure we'll be able to work out something that suits everyone's needs.
Just on that note, Mr. Chairman, I've got numerous people from White and Case here. Mr. Bennett's been good enough to come down today, so we might take the opportunity to maybe to take him aside before we all disappear today, and see if we can resolve that with the itinerary.
Okay, thanks everyone. They were the only matters I needed to talk about.
I do have an update on the, if I can call it the soils conclave. Apparently that has now been uploaded as a signed document. I think what occurred is that Mr. Sonigan sent back the signed page. So we've compiled it into a full document, but then sent an email explaining that that's what we've done, just so that when you see it, you understand that we have compiled it with the full set of signatures.
Thank you.
I think that takes me to my proper opening of the case, Mr. Chairman, unless there's any other matters of business we need to get to. I understand that my 23 slides have now been uploaded as document 109 for those following along remotely, but I'm going to share the screen and step you through it. And as I say, it's all drawn from material already filed. So hopefully it's just going to be an efficient process that way. Just bear with me while I make sure I can screen share. Oh, Mr. Forrest is doing it. No, that's fine. That's helpful. Thank you. So Mr. Forrest is going to drive it. That's very good. What I've got on the screen now is the opening passage to the terms of reference. And what I really wanted to start with was explaining from our perspective why we're all here. You'll see in the opening passage that this inquiry and advisory committee is appointed to inquire into and report on the project and its environmental effects in accordance with the terms of reference. And so the point to be made there is that effectively the aim of this exercise is to report on just that, the environmental effects of the project, not the adequacy of the EES, the makeup of the TRG, all of the processes that have come before. Now, of course, the EES is a critical document in all of this, and it needs to be carefully scrutinised through this process. But ultimately, your task is to report on the effects of the project, and that is something that we'd ask you to bear in mind throughout. If you just step to the next slide, the first page referred to your appointment pursuant to Section 9(1) of the Environment Effects Act and Part 7, Section 151 of the Planning Environment Act. And the purpose of the second slide is really just to bring those to your attention, again, consistent with the opening passage in the terms of reference under Section 9 of the Environment Effects Act. Your task is to hold an inquiry into the environmental effects of the proposed project or works. And then under Section 151 of the Planning and Environment Act, it's a much broader, I suppose, potential jurisdiction because you're tasked with advising on any matters that the Minister refers to them, but that brings you back to the terms of reference again. Go on to the next slide. You'll see here what I've tried to bring to your attention is some but not all of the powers of the committee, and specifically the general procedure for hearings. And we've got on the right-hand side of that slide some of the matters that have already come to your attention this morning through discussion of the terms of reference. So, of course, you're to act according to equity and good conscience without regard to technicalities or legal forms. You're bound by the rules of natural justice. You're not required to conduct the hearing in a formal manner. You're not bound by the rules or practices to evidence, but may inform yourself on any matter in any way that you think fit, and without notice to any person who has made a submission. And they're fairly significant powers of inquiry that make up the proposition that we're here for an inquisitorial rather than an adversarial process. You'll see also that there are other powers such as the ability to prohibit or regulate cross-examination and to take submissions and evidence orally or in writing. So VHM really sees its role in this process as being to assist the IAC in undertaking that task. To that end, we've adduced numerous reports of expert witnesses, as you'll have seen through all of the filed material. We are endeavouring to produce responsive material to answer questions as and when they're raised. Some of those take a bit more work than others. So the RFI responses, for example, remain a work in progress to some extent, but we're trying to bring as much information that is responsive as we can, as soon as we can. What we intend to do in order to assist you in your exercise is that at the opening of each day, because we do have sort of not quite topics, but, you know, for example, tomorrow we've got a general theme of soils and rehabilitation and agriculture. The next day we've got flora and fauna. What we intend to do ahead of each day is when we file the presentations of each of our witnesses in accordance with the directions, we're also going to be filing outlines that really summarise the nature of the topic in question, that point you to where in the EES, where in the technical reports, where in the evidence do you look for material that's relevant to that subject matter, indeed where in the EMF and the mitigation measures are there items of relevance, and then trying to summarise the key issues. And I don't think you'll have seen it yet, but I understand we are in the process of filing material to that end for tomorrow's discussion on soils, rehabilitation, agriculture, with a summary outline that sets out what we see as being relevant to that. So we thought that would be a useful way to try and give you guidance ahead of each day to what we're going to be dealing with that day. Of course, parties might think other issues are key and want to bring those to your attention, and they'll have the opportunity to do that when they present their own cases. But that's the way we intend to organise our time. As I've indicated, we'll then be doing a Part C submission that's responsive to everything that you've heard, and a Day 2 EMF and incorporated document to that end. I will be calling 3 presenters, as I introduced this morning, and their presentations have all been filed. I'd ask that those presentations be taken for what they are, which is a component of my opening submission and not as evidence. They're certainly not intended to be taken as being, for example, expert witnesses, but rather here to assist the IAC first through an introduction to my client, which is an important component for my client's perspective, and then to explain in more detail the mining and processing components of the project. I should say, though, that because, of course, there'll be matters of fact brought to your attention through, for example, discussion of the hydromet facility and the other processing components, we would indicate that Mr. Williams and Mr. Beer are available for questions of clarification about those matters, of course, from the committee. But we don't put them forward as expert witnesses, and that's why we haven't filed expert evidence to that end. So now we come to the project in its context. On the left-hand side, you see the project location in its very broad context, namely in the Loddon Mallee region, some 35 kilometres from Swan Hill. This is an area characterised by flat to gently undulating land that's largely cleared of native vegetation, except for pockets of bushland and within road and rail reserves. It's characterised largely by broadacre farming consisting of dryland cropping. And the proposed mining area, and you'll see the proposed mining area probably better on the right-hand side of that slide, which has the yellow Goschen project outlined. That area comprises 4 properties, one of which accommodates a dwelling, and VHM has negotiated to acquire the freehold of all 4 parcels. And it was a conscious decision by my client to not seek to do this on an involuntary basis. You'll see on the right-hand side as well that the Goschen project is a smaller component of a number of exploration licences and retention licences that my client has secured under the MRSD Act. But as noted, we're consciously looking to exploit the resource where we can do so on a voluntary or negotiated basis, if I can put it that way. The project rationale was set out in some detail in Chapter 2 of the EES, as you will have appreciated. I don't intend to go through all of that rationale there. It remains there to be read. But in short, this is what we would describe as a globally significant mineral sands and rare earth project. It involves the mining and the processing of heavy mineral sands and rare earths at a throughput of approximately 5 million tonnes per annum of ore over a 20 to 25 year period that would produce firstly 2 heavy mineral concentrates. So that's titanium and zircon. The titanium, as you will have appreciated, is particularly useful in TiO2 pigment manufacturers' work. So for a pacifier, brightener, UV protector applications in paint, in industrial coatings, in plastics, laminate materials and paper.
Sorry.
Not sure what that sound was.
It's used in paper.
Yes. And also in welding, electrode and titanium metal industries. And as set out in Chapter 2, there's a growing demand, particularly for the higher grade feedstocks. In respect of zircon, it's largely applied in the ceramics industry, predominantly tiles and sanitary ware, as well as refractory, foundry and specialty chemical and materials uses. And the global supply is predicted to be in deficit by 2030 for that material. If you can go to slide 5, the project will also produce rare earth mineral concentrate. And I've just set out there table 2-1 from chapter 2, which sets out all of the various end use categories and descriptions for the various rare earths that we're talking about here. They're typically used in small amounts, but they're necessary for hundreds of different technologies, materials and chemicals worldwide. And specifically permanent magnets is a major one that's drawn attention to in chapter 2, and specifically electric vehicles, which are expected to grow from 10 million in 2020 to almost 150 million in 2030 globally. As demand grows, availability is also becoming increasingly scarce. Now, just to finish off on that point, I was just going to take this as an opportunity to introduce Ron Douglas to present to you on VHM. He is the CEO of VHM, and if I can just ask him perhaps to take a seat in the expert witness chair, and I'll ask again Mr. Forrester to share that presentation as he steps through it.
Thank you, Emma, and thank you, Chair. I'll keep this very brief. It is, I just wish to introduce VHM as a company to everyone here. And if we jump to the next slide, thanks. And this is all publicly available on our website, but essentially we are an Australian-owned company. It started as 2 geologists getting the data from earth resources and contemplating where rare earths could be found. In fact, it was along the Boga granites. And so they went to family and friends and raised some capital. Then they went back again and they raised some more because it cost money to explore. And eventually we got to the size where to look to develop and run through this process. We publicly listed in January of 2023. And the purpose is to access some funds from the public. So essentially ownership is 99.5% Australian. Mums and dads, essentially, that's where we got the funds from. Some super funds, and it's just an Australian company doing Australian investment who wish to invest in mining. Next slide. This is the board management team. You'll see myself, of course, as the CEO. I provide leadership and enable resources to the company. And Bernie, who is also in the room, is a Victorian-based individual who will be the operational executive. So he knows it very well, been working here for a long time. We've 3 or 4 of us on that team have been together for 25 years. We've done numerous developments. And so work together closely, and we sort of, mining is a very close unit, and we have a tendency to, where we see our friends go, and we go and we support as well. Next slide. What attracted us to Goschen in that is the fact that, I'm showing my age now, but 40 odd years in the mining industry. I've been doing this all around the world, numerous countries. This is, I consider, the most environmentally sensitive mining approach that I've ever seen. It is, in fact, moving through extracting the heavy minerals and then putting it back in the void where it came from. So the CO2, because nature has done all the work for us, it was the inland sea eroding the Boga granites. It is a very low energy footprint, and it really is looking at the processes we use, and I know there's going to be some debate during the period of time. However, the processes that are used worldwide, we've been associated with them for a long, long time. So not in the mineral sands here, but certainly everywhere else. I'd say hydromet circuits have been around for 50 years. Looking at what it can do for the community, and I know there's, people feel threatened by the impact of a mining company arriving, but if we actually have real experience with Orange, with the Cadia project and others that I can name where the wealth of the area, and that was concurrent, agriculture and mining working together, and there's still great agriculture, still mining, the wealth of the whole region grew. So I'm really excited for the potential, and it brings a lot of benefit. And the migration of people away from the area this will enable them to come back and actually get jobs that are different. So it'll actually encourage the local area. So that's why we came to this project, in that we just saw great opportunity for everyone associated with it. Next slide. Quickly, Emily just spoke to these. These are the products which the NdPr essentially are the magnets that are currently produced from China. We also, through this asset, have access to dysprosium and terbium, which are the heavy rare earths, and they will enable everything to size down smaller, and it is incredibly important to us. The zircon and titanium, it's a dual stream. One is heading towards paints and pigments and tiles, and goes to the urbanisation of the world. So as China urbanises, it uses more of that product. We've got India to come, we've got all these. So there's a growing need for this. And however, the rare earths is what is important to us. It's what's decarbonising the world at this moment in time. We're all moving away from carbonised fuels, and this is a great enabler. And just to illustrate that, next slide. And these are where rare earths are used. And in fact, every device, I look around here and go, yeah, full of rare earths. And so right now, 90% from China. If the Western world is going to enable themselves to develop and decarbonise, then it's pretty important that assets like this move forward and get developed. It's the big growers in this, as mentioned, are electric vehicles and the wind farms, and that is because if you want to shrink and enable this to get away from the heavy copper wound, you need the permanent magnets which come from the rare earths. So they're very important if we're going to actually move to the future that we all talk about and government's talking about. So thus I'm a big enthusiast of it. And that's sort of us, and that's why I'm here. And so looking forward to the process, which is a democratic process. Thank you.
Thanks, Mr. Douglas.
Thanks, Mr. Douglas.
I'll just ask Mr. Forrester to go back to my slide deck. So you've heard about the proponent. You've heard to some degree about the project. I've got on the slide here figure 1-5, just setting out the project area in its entirety. So on the right-hand side, you've got the pump station, then you've got the exhibited alignment, which was the topic of some discussion this morning. For the pipeline, you've got the mining licence area, and then the dashed line is the transport route upgrades that go to the Ultima railway siding, which in itself is a fairly significant facility. I don't intend to take you through exhaustively the full project description. You can find it discussed in Chapter 3 of the EES, and we've then gone and summarised some particular components of it in paragraphs 7 to 14 and then 18 to 73 of Part A submission that I'll assume can be taken as read. If we go to the next slide. What I did want to emphasise though was one, I suppose a couple of aspects of the proposed process. And this first one to note is that the mining will follow a sequential cycle. So this is taken from, again, Chapter 3, Figure 3-9, the mining sequence, so that the active mine pit will move across Area 1 and then Area 3 in blocks, and each of those blocks is approximately 500 metres in length, with each block being progressively stripped, and you can see that in plan and then section form here, progressively stripped, mined, filled with tailings and rehabilitated and moved on and on and on. So while you have a total disturbed area of 1,479 hectares, at any point in time, the disturbance footprint will be in the order of 60 hectares. And that's an important component of the project that we want to bring to your attention. The mining operations will be above the regional groundwater water table with a depth of between 20 and 40 metres below ground, with no indication at this stage that drilling or blasting would be required. I just want to go to the next slide. What I've then set out at table 3-1 is the phasing of the on-site processing, which does take a little bit of describing. So the processing on site of the mineral products is a feature of this project, and it'll be done in the phases set out in table 3-1. You'll see that phase 1 commences at commencement of operations. The relevant plant or circuit is the mining unit plant, the wet concentrator plant, and the rare earth mineral concentrate flotation plant, and they're consistent through each of the phases. And the products you get from there are the heavy metal concentrate and the rare earth mineral concentrate. Phase 1A is then planned to commence some 6 to 12 months after project commencement. Again, you've got those same processing plants or circuits, but added into that is the hydromet circuit. And that's where we get the mixed rare earth carbonate being processed. And you can see that at the bottom of 1A. And then phase 2 is construction being planned to commence around 2 to 3 years after the overall project commencement. You've got, again, the same processing plant or circuit, but you've also got the mineral separation plant. And then we've got in there the more specific products that are intended to be created through that process. Now, we're all conscious that it's the processing components that probably require a bit more explanation. And so it's at this point that I'd like to introduce we've been calling them the Gavins, Gavin Williams and Gavin Beer. They've both prepared presentations which have been filed in advance. I'll just indicate Gavin Williams is the principal consultant metallurgist with TZMI, and Gavin Beer is the principal consultant metallurgist with Metchem Consulting, both of whom are consulting to my client in this project. I'll ask, and that they're appearing virtually from WA. So if I could just ask them to turn their I assume that Salvaraj, they've been promoted.
Gavin Williams is there, he's in the panellist room, but I haven't been able to find the other Gavin yet.
I might ask Mr. Williams to turn on his video. I think Mr. Beer's in the waiting room.
What name would he be under?
He's actually sitting in the waiting room.
Oh, just out here.
No, here under virtual way, and that was when I was making that noise.
Has he dropped out of the participants?
I'll text him now.
He just is not under his name, so he could be. There's a CPYO.
He might have dropped out altogether, in which case we need to get him back in. I can't see him. Just while we're waiting for Mr. Beer, Mr. Williams, if you can hear me, can you just turn off your mute and introduce yourself so that we know we can hear you?
All right. Good afternoon, everybody. Hopefully you can hear this.
It's fairly distant. Is there any way you can adjust your microphone or volume so we can hear you a bit better?
Yeah, let me have a look. It was set to auto adjust.
That's fine. Yep, we can hear you now.
Have you got a volume on your side you can adjust maybe?
No, I think it's come through now. That's fine.
Okay, great.
Just waiting on Mr. Beer.
Ms. Potter, is Mr. Williams talking to the VHM presentation on the mineral sands plant process overview? PD 97.
Just while we're waiting, Mr. Williams, can I just check, are you prepared to do that presentation without Mr. Beer, or do you need Mr. Beer to come in for the duration of the presentation?
No, happy to do it without Mr. Beer.
We might just keep it going that way.
He'll be covering the hydromet plant, which is separate to what I'm doing.
Yes. I've got Mr. Forrester sharing that presentation, Mr. Williams, but if you could just start by introducing yourself so that we know who you are.
Okay, very good. Yeah, my name is Gavin Williams. I'm with a company called TZ Minerals International that operates in the mineral sands processing space. So we also do market consulting. I've been involved in mineral sands mining and processing for over 25 years by now, starting at Richards Bay Minerals in South Africa. And then I joined TZMI in 2008 and have been involved in mineral sands plants and operations since then. conducting due diligence reviews, plant reviews, scoping studies, pre-feasibility studies, test work programs, and so on.
So, Mr. Williams, I'll invite you just to commence the presentation.
All right, very good. As has been sort of alluded to already, my experience revolves around the mineral sands process plant side of things. And I'm going to be covering off on that aspect of the process plants, which really is the front end ahead of the hydromet plant. Okay, if we can just move on to the next slide. All right, I guess the first thing that's really worth mentioning is that the minerals that are being mined by VHM are present throughout the Earth's crust, but not always in economic concentrations. So, fortunately, nature in some areas concentrates these various minerals either by water, wave, or wind action to the point where they become economic and can be mined and processed. So this is just a little diagram giving an example of that. You can see there the highly concentrated mineral sands layer. Probably worth pointing out that the same or similar processes that are involved in concentrating these minerals that you find in the ground are actually utilized in the processing plants by exploiting their differences in their physical properties, which we'll talk a little bit about later. Next slide. Okay, this slide really just gives an indication of the relative proportion of the material that's going to be removed from the material that's mined. So most of the material out there in the deposit comprises low density quartz minerals or particles, and a small proportion of that, about 5%, is the heavy minerals. So obviously we call them heavy minerals because they're more dense than the quartz. And it's one of the main physical properties that we utilize to separate the heavy minerals or the valuable heavy minerals from the low value quartz. So that pie diagram there shows a relative proportion. So that light blue coming out of the top pie indicates the heavy minerals. And then within the heavy minerals, we typically refer to it as a mineral assemblage, which refers to the different minerals that make up the heavy minerals. So in the case of the Goschen project, we have ilmenite present, zircon, high-tie have lumped together, which really comprises the rutile and leucoxene. So these are titania minerals with higher TiO2 contents, typically above 65% TiO2. And then a small proportion of that is the rare earths. Right, I think that covers everything there. All right, now the physical separation processes that we utilize in the plant, as I alluded to, really take advantage of the difference in the physical properties. So these separation processes that we're going to be talking about ahead of the hydromet plant are physical separation processes. So what we utilize there are differences in the density of the minerals, sizing, magnetic susceptibility, surface conductivity, hydrophobicity, and we utilize those differences in physical properties to generate the final products from the mineral suite, which the minerals of interest in this case are ilmenite, rutile, zircon, leucoxene, and the rare earths. That image there on the right just gives a sort of a microscopic view of what those individual particles look like. So in the case of the Goschen project, they're relatively fine. That size fraction there was screened from material that is coarser than 20 microns or 0.02 millimeters and finer than 1 millimeter. And that is the 4.05 SG fraction. So those are minerals with a density greater than 4. Okay, moving on. Right, this next slide really just gives an overview of the mineral sands processing operation. Excuse me. So you can see there, top left-hand side is where the mining takes place. Material is mined and put into a mining unit where it gets slurried with water. That slurry then gets pumped a short distance up to the process plant area into the feed preparation plant, or we call that FPP. We'll talk a little bit more about that later, so I won't give too much detail now. This is really just an overview. The next stage is the wet concentrator plant, or typically abbreviated to WCP, which predominantly utilizes difference in the particle density to reject the non-valuable light minerals, particularly the quartz. That produces what we call a heavy mineral concentrate, or abbreviated to HMC, which then undergoes further processing. So the HMC contains the mostly the valuable heavy minerals, so ilmenite, rutile, zircon, leucoxene, and rare earths. And the wet concentrate is not a perfect separation, so there's a little bit of quartz that gets entrained and goes in with it. So that HMC is about 90% heavy mineral and 10% quartz. That then goes into the rare earth flotation circuit, where the rare earths are floated, producing a zircon titanium concentrate. So obviously that includes the minerals apart from the rare earths, which then undergoes processing in the mineral separation plant, or MSP. The REMC then goes on to the hydromet plant. I've just given an indication there by brackets. It's already been discussed in terms of the phases of the project, but that really shows what it means from a processing point of view. So you've got there phase 1, which goes up to HMC, phase 1A up to the hydromet plant, and phase 2, the MSP. Right. Oh, yeah, I guess the other thing that's mentioned there on the slide is that the tailings, which, as we've mentioned in the previous slide, makes up the bulk of material that gets mined, is pumped back and used to fill the mine void, the overburden placed on top, and then allows the area to be here rehabilitated. Okay, next slide. Okay, so yeah, this really just gives an overview of the mining area. So essentially the economic concentration of minerals occurs below the surface. So there's an overburden which contains uneconomic heavy minerals that needs to be removed first, which allows access to the economic zone. That then gets mined and pumped through to the FPP. And then, as you can see there, the mining progression on that diagram starts in the lower left-hand corner, which is where the topsoil clearing takes place, overburden clearing. Then you can see the mine face. That material gets pumped to the wet concentrator plant, and then the tails are returned to the back of the mine. So you can see there what looks like a pond there. That's a tails return. So those bunds are constructed to contain the tailings. Once the tails are pumped back to the mine void just as a slurry, and then the water is released from those tails and it gets recirculated back to the plant. So most of the water gets recirculated back and reused. And there are a number of processes which I'll mention in the process plant there, with the main objective of recovering water from the various process streams so that we can reuse it. So once the tails are returned and dewatered, overburden gets placed on topsoil on top of that, and then the area can be rehabilitated to farmland. Probably just worth mentioning there, you can see that the top of that diagram there is the process plant. Just mentioning that just to sort of so you can orientate yourself to what the mining and processing site will look like. Okay, next slide. Right, I'll now talk in a little bit more detail about each of these main processing plants. So that photo or 3D representation of the mining unit plant, you can see that there comprises a conveyor and a scrubber trommel, which is the first stage of screening. Particles coarser than 40 millimeters are screened out and rejected at the end of the trommel, and then those obviously get returned back into the pit. And then the minus 40 millimeter fraction is slurried and pumped up to the FPP. You can see the plant there in the background. So front end loaders will load that hopper, which then feeds onto the conveyor. Okay. Right, there's again a 3D representation of what the process plant will look like, just so you can orientate yourselves and become familiar with the terms that I'm going to be using. So if you're on the right-hand side there, you can see the label feed preparation and then concentrated plant. So that feed preparation plant, as I mentioned already, receives the slurry from the mine. It essentially is a screening operation. And the sized fraction, so that typically is minus 2 millimeter plus 20 micron material goes into the concentrator plant, which you can see there just to the left of the feed prep plant, where it gets concentrated to produce an HMC, and the bulk of the tails is produced there. The HMC then gets transferred either directly into the rare earth mineral recovery plant or onto a stockpile. There's an allowance for an intermediate stockpile. So that's what that shed is, just in front of the rare earth plant, where flotation and gravity concentration is used to produce the rare earth concentrate, or REMC. And then the zircon titanium concentrate, again, can also get stockpiled in that shed or transferred directly to the mineral separation plant, which is sort of on the extreme left-hand side. You can see the label. And then that generates the final products for sale, and that gets those get put into containers and loaded onto trucks bound for Ultima, and the product loading area there just to the left of the rare earth recovery plant. The hydromet plant that Gavin Beer will talk about is located at the back of that image there. So hopefully that helps to orientate yourselves and become more familiar with the processing stages. Okay, next slide. Right now I'm going to talk in a little bit more detail about each of those processing stages. So the feed preparation plant there essentially is a series of screens and then desliming cyclones. So the material gets pumped in, gets screened down at 2 millimeters and goes through a desliming cyclone. So the idea of the desliming cyclone is to remove the particles that are finer than 20 microns, which typically the wet concentrator plant can't actually recover. So we remove them because that allows to improve the separation efficiency in the wet concentrator plant. There's another fine screen in there at 350 microns to reject some of the non-valuable heavy minerals. So not all of the heavy minerals are valuable, and there are some non-valuable heavy minerals which we've found to be relatively coarse. So that 350 micron screen helps to reject some of the non-valuable minerals that would have ended up in the HMC. That sized fraction, which is minus 350 microns plus 20 microns, gets pumped into a large surge bin ahead of the wet concentrator plant. Okay, move on to the next slide. Okay, in the wet concentrator plant, essentially we have a series of spirals. So these are gravity concentration spirals, widely used throughout the mineral sands industry for many, many, many years. So they utilize the differences in the density of individual particles to concentrate them. So that slurry gets pumped up to the top of that wet concentrator plant, and then as that material, that slurry, flows down those spirals or sluices, as some people call them, the heavy minerals get concentrated on the inside of those spirals, and the low density gangue mineral on the outside by the hydraulic action and the washing action of the water. Essentially, it's the same as these minerals concentrated on beaches via wave action. So it's the same kind of thing, but just happening in a spiral plant. Those are concentrated to about a 90% HM. And then there's a final screening stage at 200 microns, as I mentioned before, to reject some of the non-valuable heavy minerals that are, greater than that size range. Most of the water there is recovered and recycled. So we've got the underflow from the cyclones of the FPP plant that go into the thickener, where those fine particles settle, which allow the water to be recovered. And then the tails from the gravity concentrator plant get pumped through a cyclone, which allows most of that water to be recovered from that tail stream as well. So like I mentioned, it's fairly conventional. These plants are utilized all over the world, and various plants in Western Australia and over east, and it employs gravity spirals and fine screening. So yeah, it's practiced, quite widely. Don't think there's anything that I've missed there. The only thing maybe I can mention is that there are a number of stages of gravity separation, so it doesn't all happen in a single stage. We've got various streams that are generated, cons, mids, and tails, and they get recirculated around through various stages to result in that 90% HM that gets produced at the end. Yep, next slide. So that's just a photograph of a wet concentrator plant located in Western Australia. You can see there's processed water plants. That green-looking cylindrical piece of equipment is a thickener, which allows water to be recovered from the fines fine particles that are ejected in the FPP. And in the background there, you can see a typical wet concentrated plant. So that one's about a 600 tonne an hour, which is similar to what's proposed for Goschen. Okay, next slide. Excuse me. Okay, so the HMC then flows through into the rare earth flotation circuit, which is the circuit that separates the rare earth minerals from the other valuable heavy minerals. So essentially in the rare earth flotation circuits, as the name would suggest, flotation is used to separate the rare earths from the other valuable heavy minerals in what's called a phosphate float. So essentially what this process does is utilizes differences in hydrophobicity of the particles. So the rare earth particles are conditioned to be hydrophobic. So what happens is in those units, they get agitated with air, and we've got a whole lot of bubbles in there, and the rare earth particles want to get away from the water, so they attach to the bubbles and float up to the surface, and the other valuable heavy minerals remain in the water. They don't attach to the bubbles, and that's a process of flotation that separates the rare earth minerals from the other the other valuable heavy minerals. So that circuit, again, utilizes conventional processing equipment. There's an attritioning stage up front, which helps to clean up the surfaces of the particles. And then we have the flotation circuit itself. The rare earth concentrate, then there are some other minerals that entrain with it. As I mentioned before, the separation processes are not perfect. So there's a final cleanup stage there using wet shaking tables, which again exploits the differences in the specific gravity of the various minerals to separate a concentrated rare earth mineral concentrate from the non-valuable minerals as well as the other valuable heavy minerals. And then there's a final washing stage in an upcurrent classifier, which really is a vessel that we allow water to flow up, which removes the fine low density particles. So that results in a rare earth mineral concentrate, which gets pumped across to the hydromet plant. And then the other concentrate left over is the zircon titania concentrate, which contains the other valuable heavy minerals, zircon, ilmenite, rutile, and leucoxene. Just a couple of photos and images there really showing what attritionists look like and flotation cells. Again, flotation is used quite widely throughout the minerals industry. And then there's a 3D representation of the plant. And that image at the bottom is a shaking table, which separates minerals based on their density. And again, water is used as a transfer medium throughout the plant. Okay, next slide. Okay, so that really is a block flow diagram. Starting the top left-hand side, you can see the mining unit plant into the feed prep plant, which is a short distance from the mine. Then everything else from feed prep plant onwards occurs at the same site. You have the sized feed pumped into a surge bin, and then you have an overflow from the surge bin and the fines fraction from the feed prep plant, which flow into the thickener, which really allow for the recovery of water from that stream. That recovered water then goes into the process water pond so that it gets recirculated back. The wet concentrator plant comes after the surge bin, as I mentioned before, which separates out an HMC, and the tails get pumped from that to the mine void. I think worth mentioning at this stage that the tails from the wet concentrator plant are combined with the thickener underflow. And the MSP tails and homogenized and then pumped back to fill the mine void. You can see the stockpiles there. Indicated the HMC in the shed and the zircon titania concentrate in the shed, and the rare earth flotation circuit with the floats going through to gravity upgrade and then into surge bin onto the hydromet plant. And the zircon titania concentrate can either be processed further or can actually be sold on as a product if needed. Yeah, okay, I think I've covered all of that. Right, the mineral separation plant, or MSP, involves processing of the heavy mineral concentrate that is produced from the rare earth float plant. And that separates the heavy mineral concentrate into its individual final products by rejecting non-valuable minerals such as chromite and goethite, tourmaline, and a little bit of quartz that ended up in those streams as well. It involves a combination of wet and dry processes. And excuse me, the equipment essentially involves low intensity magnetic separators, wet high intensity magnets. There's a flotation circuit to clean up the ilmenite, a hot acid leach to clean up the surfaces of the zircon, electrostatic separators which take advantages of the differences in the conductivity of the surfaces of the particles, and then there's a number of screening stages. So the mineral flows through those various processing circuits to produce a final ilmenite product, a zircon product, a high-tie rutile product, and a leucoxene product. It's possible that they're similar products, so the high-tie rutile and leucoxene could be combined into a single product because essentially those would be targeted for similar markets. That diagram or that photograph at the bottom right-hand side there shows an example of an MSP. Just in the background there behind the stockpile. So that's what an MSP would look like there. Okay, moving on. All right, the MSP is, I guess, relative to the other plants, fairly complex. It involves a number of different separation stages. So you've got the zircon titanium concentrate that comes in and gets separated via a WIMS, which is basically a wet magnet, producing a non-mag and mag stream. The mag stream is the ilmenite, ilmenite-rich stream, which then goes to a flotation circuit, which removes the chrome-containing minerals and produces an ilmenite product. The non-mags goes into a non-mag upgrade circuit, which there we exploit differences in density to produce a higher grade concentrate, which then undergoes further processing to produce a zircon, which is a non-conductor, and then high-tie rutile products. So that really just summarizes that flow sheet there. It's a little bit more complex than what we've seen in the preceding circuits, but it's again fairly conventional mineral sands processing techniques and technology that's used throughout the industry. Okay, next slide. Right, yeah, I think this is the last slide. So really this just gives you an indication of the starting point and the end point. So we have there, mineralized sand as it comes out of the ground, undergoes those various processing stages, and then, those are sort of relatively speaking in terms of sizes, what the different products will look like. So, ilmenite, zircon, the high titanium minerals, and then the rare earths at the bottom. And I think that's the last slide.
Thanks, Mr. Williams. Just before we finish sharing that presentation, I just wonder whether the committee had any questions that would like to ask Mr. Williams at this stage before we then turn to Mr. Beer.
Mr. McIntosh.
There's one process that hasn't gone into a great deal, and that's the acid bake. Is that something you're able to talk about or not?
That occurs in the hydromet circuit, and Mr. Beer will be talking about that in his presentation.
I will hold my questions for him.
Okay, very good.
Ms. Bell, do you have any questions?
No, thank you.
Look, just one from me. The process plant diagram at page 8 of your presentation, it's similar to, but not the same as the project plant visualisation in the chapter 3 of the EES. I suppose this is just a very general question, but given that they're conceptual plans, would you expect that there would be any significant changes to the general arrangement and composition of the plants?
I mean, the processing elements will stay the same. I guess it's possible that, some of those, the locations of the individual plants might change, but, in terms of where the site occurs, that will remain the same. we might move some of those plants around, but broadly speaking, that is the orientation and the location of those various processing plants.
So is there some scope for flexibility in the locational arrangements within the plant?
I mean, yes, there is some scope for movement. Obviously, you want to optimize the flow of material from one process plant to the other. This image that you see on the screen now was taken from an early video that was generated by the project proponent.
Okay, thanks.
Thanks, Mr. Williams. I'll get Mr. Forrester to stop sharing. I did see Mr. Beer had joined and been elevated. So, Mr. Beer, if you're there and can hear me, if you could turn on your excellent. Can you just briefly introduce yourself in part so we can make sure we can all hear you?
Certainly. Just checking my audio. How does that sound?
Sounds good. Nice and clear.
Good. Okay. Brief background to myself. I'm a hydrometallurgist, 35 years postgraduate experience, chartered professional of the Australian Institute of Mining and Metallurgy. I'm a competent person under the JORC reporting, and I'm also a qualified person for NI 43101 for the North American TSX reporting. I hold my own consultancy, which I've had since 2012, specialising in critical minerals, mainly in rare earths. I've consulted to over 50 rare earths companies in my consultancy since 2012. Currently consult to about 5 or 6 rare earth companies.
I'll just ask Mr. Forrester now to share document 98, which Mr. Beer is the, I can call it the hydromet presentation. And I'll get Mr. Forrester to drive the control. So if you just ask him when you'd like to move slides, but I'll now invite you to present this material to the committee.
Great, thank you. This slide that's presented at the moment was previously presented by Mr. Williams, just to put this into context. So phase 1, which he has described, is the mineral upgrade plant, which does not involve hydrometallurgy. So for context, if we can move to the next slide, which is phase 1A. And this is where we are introducing the hydrometallurgy plant, which takes one of the product streams, as previously described by Mr. Williams. We call this the rare earth mineral concentrate, which in essence is a mixture of monazite and a particular rare earth mineral called xenotime. This slide shows how this will integrate into the mineral processing phase, the mineral upgrade plant. We don't show a layout here, but in terms of overall area, it's extremely modest. In terms of volumetric flow, 12,000 tonnes per annum is about 1.5, 1.6 tonnes per hour of feed that will be sent on a dry basis. However, it will be actually fed through from the mineral upgrade plant as a thickened slurry or a thickened paste. I'll describe that in more detail as we go through the particular slides.
I'll just get you to stop there. I'm not sure what's happened to the shared screen, but it's gone blank. So you just bear with me, Mr. Beer.
Yeah, we'll just
Certainly.
and come back, but Mr. Beer should stay where he is.
Yeah, so you stay there. Don't do anything. Shocks me every time. Mr. Beer, I'm not sure whether you heard a query from Ms Armstrong, who's representing the EPA, but you've given us some figures relating to feed over time. Are you able to put those into writing for us to table after today?
No problem. Yes, that information is easily available.
Yes. All right. So perhaps I don't know if you can remember where you left off.
That's fine. So the purpose of this slide. Yes, so the purpose of this slide was really just to show where this fits into context of the project development. If we can move to the next slide, I believe this was previously shown. This is phase, did we move up or down there? This should be phase 2. Yes, that's correct, phase 2. No changes on the hydromet plant. So this really is, as I say, just relates to previous presentations. So there's no changes in the hydromet plant at this phase. If we can move to the next slide, please. The intent of this list was really just to show the chemicals that are brought onto site. If we can focus on the middle of the table, which is phase 1A, these are the specific chemicals that we will be using for our hydromet plant. And the middle column here shows the maximum design storage at any given time. The highlighted is sulfuric acid, and that's highlighted because it is of course a corrosive chemical, and at any given time we will have 300 cubic meters. With an SG of about 2, that relates to about 150 odd cubic meter. 300 cubic meters. That relates to about 600 odd tons, I should say. Other notable chemicals: magnesium oxide, which we also call magnesia. That will be an Australian product from Queensland, and then ferric sulfate. That's a solid that will be stored in bulker bags, in containers. You can see we have a very modest amount of hydrogen peroxide that will be brought in a bulk container, which are generally a stainless steel containers on a truck, which typically 30 cubic meters is about 3 10 cubic meter containers, or 1 and a bit 20 cubic meter containers. Sodium carbonate or soda ash for final product. And you can see there's a large volume there that we use of calcium hydroxide, which is just the chemical name of hydrated lime. So no different to what's used in the building industry for making cement. So these are the additional chemicals that are required for the hydromet plant. Again, quite modest in terms of storage volumes, with perhaps the exception of lime, which is of course well known for transporting and storing on particular sites. If we have no questions on the reagents we're bringing in or storage, I can move to the next slide.
We might have some questions at the end, Mr. Beer, so we'll just, unless
of course,
let's get going.
No problem. Now, the intent here of my presentation is to try to make it as simple as possible, the hydromet flow sheet or the process that we're using. As an overview, what we are really trying to do is to value add from the rare earth mineral concentrate that I described earlier to a mixed rare earth carbonate product. The reason that we do this is that, of course, it adds value, but this is a direct feed into the next phase of plants that are used to make permanent magnets. Electric vehicles, wind turbines, of course, are the growing markets for these products. The challenge that we have, as do our peers, are that the minerals that have been recovered, the monazite and xenotime, they are very resistant minerals, so that they require quite an intense heat and chemical treatment in order to release the rare earths from them. We have selected a process known as the acid bake process, which is the most commonly used process worldwide. The final figures out worldwide production for rare earths in 2023 haven't been released, but it's approximately 200,000 tonnes of rare earth oxide products, most of which, of course, comes from China, approximately 85%. However, by volume of these rare earth oxide products that come, approximately 90% have been produced through the acid bake process. So it's a very well-known process. The examples that I give here of the process is Lynas Malaysia, which will be closing in the coming year or so. And they are building a new facility in Kalgoorlie, which is presently under construction, due for final commissioning this year.
Mr. Beer, I don't know if you can hear me. We've just lost the feed again. Just stay with. All right, Mr. Beer, we seem to be back. Just taking us to the Lynas example.
Yeah. So what I wanted to highlight here is that Lynas has operated for many years in Malaysia and also building the latest version of this in Kalgoorlie, as are Iluka here, just north of Perth. Baotao, being the largest producer of rare earths in China, they use the acid bake process. Arafura in the Northern Territory has ordered their acid bake kiln. And what I haven't included here, I found out just recently, is that Hastings, also in Western Australia, have placed their order for their acid bake kiln. It's worth noting also that the acid bake process is exactly the same as the front end of the lithium spodumene production process. So there are 3 in construction here in Western Australia. So 2 in Kwinana and 1 south of Perth at Kemerton. So spodumene is treated initially exactly the same as the rare earth mineral concentrates. So it's a well-known process, but I will focus a bit more in my next slide, particularly on the acid bake. So if we can progress to that now. The general flow sheet, and essentially, whilst this looks fairly complex, it really relies around an acid bake, a water leach, and then purification, which is a 2-stage purification before we make this mixed rare earth carbonate value-added product that will then be sold to third-party refiners. I've got a description here on the left-hand side, which is available to everybody, but in essence, we feed a mixture of sulfuric acid and the concentrate, which forms a paste. We put that into the kiln, we bake that at about 280 degrees Celsius, which then discharges directly into a tank that leaches away the rare earths. That leaves behind a residue, which is then neutralized along with other wastes, which I'll talk about later. The acid bake process, unfortunately, also dissolves some of the impurities that we need to remove, mainly iron and aluminium. So we do that by adding magnesia, which is the magnesium oxide. It leaves quite a clean solution of rare earth sulfate in solution with a little bit of uranium contamination. And by a little bit, I'm talking about 40 parts per million, something like that. So very low uranium. However, we need to remove all of the uranium. So we then go through the ion exchange process before we go finally to the rare earth carbonate precipitation. You can see here that in the water leached solution purification and also the uranium removal is that they all form tailings which go to a neutralized residue that then joins back with the tailings from the mineral upgrade plant. These tailings are an exceptionally small percentage, with single-digit percentages or less compared to the tailings that we produce in the mineral upgrade plant. If we go to the next flow sheet, I'm going to go through each of these step by step. So the acid bake, I heard a question from before, and I know there's some interest in this. The rare earth mineral concentrate that we take from the wet concentrator comes as a slurry. We first filter that and then we dry that. The dried material is mixed with sulfuric acid, and we then send this to a rotary kiln. We have an advantage here at Goschen in that, given we have a modest feed rate compared to our peers, we've selected state-of-the-art rotary kiln, which is what we call an indirect fired kiln. What this means is we don't have large volumes of flame-fired gas going directly onto the product. So we actually generate very little volumes of gas that actually needs treating from the kiln. I haven't shown it on this diagram, but the off gas from the kiln goes through a three-stage process. The first stage is what we call Venturi scrubbing, and this actually recycles 99% of our sulfuric acid and removes 99% of the dust particulates. We reuse that acid further in the process. After that, the gas then goes through a cleanup stage, and this is actually where we put the gas through a lime scrubber, and that removes better than 99.9% of the sulfur dioxide. And then finally, just for safety, we go through what's called an electrostatic precipitator in case any of the final dust comes through. This is a standard process that's utilised by all of those examples I started off the presentation with, for the rare earths operations that are being constructed along with the spodumene. And the process is actually designed by the international suppliers. We've chosen to work with a supplier that is installing at Iluka for Kalgoorlie for Malaysia, and also in Kwinana for the one of the lithium refineries. So we provide them what the particular EPA requirements are, and then they design and give a process guarantee with respect to meeting those requirements of acid, sulfur dioxide, and particulate particulate discharge. Okay, so as I said before, a very modest amount of feed, 1.6 tonnes per hour. The kiln itself is not particularly large, 1.8 metre diameter, 12 metres long. And that drops straight out into our next phase, which is the water leach tanks. What I've done here is just showing some typical examples of what the equipment looks like. As I said, we have to mix the acid with the mineral concentrate, so they are simply paddle mixers, almost like a large food processor. To put this into context, this is approximately 3 meters long, so it's not a particularly big unit, and about 1.5 to 2 meters tall. Below that, the acid bake kiln, which I've talked about the dimensions. This one, there's an example of the indirect fired where the flame goes on the outside of the tube. And a typical wet scrubber, you can see here the cyclone, classification cyclones. This actually doesn't show all of the stages, so we're not showing acid recovery here. So this is just a generic diagram that I had. I can move on to the next phase unless somebody had a particular question about the acid baking.
I'm in the committee's hands as to when it wants to ask any questions.
We can wait.
No problem.
Just continue, Mr. Beer. Thanks.
Sure. Look, I've grouped here the water leach and the solution purification because when you actually look at these, they are in essence just stirred tanks. These tanks look exactly the same as any gold mine processing or any copper leaching. So they are either lined steel tanks or they will be reinforced polymer, i.e. plastic tanks. So in essence, we come from the kiln into the tanks. They're quite modest. They're 54 cubic meter tanks of 4 each. We then thicken those and filter. And then the rare earth liquor is pumped in the purification tanks. The idea of this is we put in the magnesia, ferric sulfate and hydrogen peroxide, and that removes the contaminants I talked about before that we don't want to carry through, the iron, aluminium and thorium, any thorium that leaches. Again, those impurities are removed by thickening and filtering. And as you can see in the diagram, they're sent to the neutralization residue tank, which then gets sent to the combined tailings. The resulting solution that comes out is very pure with some minor uranium impurities. If we go to the next slide, I'll show you what some of that equipment looks like. Again, the stirred tanks, our particular tanks are quite modest. They're about 4 meters in height. So they're not particularly large. They have twin impellers. Thickeners are very straightforward. They just have a very, very slow rake at the bottom that lets us decant the solution from the solids. And the filter press, in essence, these are just cloth lined plates where we use pressure, hydraulic pressure and air to squeeze out the water in the solution. Very typical equipment, nothing particularly special in these. We go to the next slide. The uranium removal, as I said, it's very, even though we don't have a lot there, it's less than 50 parts per million, we need to remove that. We use a process called ion exchange. Now, this is a very common used process worldwide for uranium production. However, we do not have enough uranium to warrant us to consider producing a uranium byproduct. There's not enough there, and it's problematic. It's certainly not economical. However, we use the same technology of this ion exchange resin, which is the same resin and the same technology that's used in South Australia for the in-situ leaching at Honeymoon Well. From time to time, periodically, and we're talking every 2 or 3 weeks, we will remove and regenerate the resin by using the sulfuric acid we recover from the kiln. And we strip that resin, we neutralize that, and we also add a little bit of soda ash in there, which makes a very stable sodium diuranate and sodium phosphate, uranium diuranate and uranium phosphate precipitate, which is, again, as I say, very stable, environmentally stable, and that gets sent to combined tails. Coming out of the ion exchange resin, we now have a very pure rare earth solution. which is now ready to make our final product. If we move to the next slide, we should have some IX columns. And this is a package. Again, this particular one is actually typical from the uranium industry. Ours are much, much smaller than this because we have only parts per million, not grams per litre of uranium. Inside those columns, you have beads of about 1.5 millimetre resin, which traps and absorbs the uranium. Next slide, if you wouldn't mind. Now we're ready to make our final product. We use, again, 2 stirred tanks, exactly the same as I showed before. These ones are approximately 78 cubic metres. We add soda ash. Our soda ash, by the way, will probably be locally sourced. They make it in South Australia. Sodium carbonate. So we will add that, and that actually now precipitates our final form of the mixed rare earth carbonate. We simply need to recover that by thickening, by filtering, by drying, and then we put these into our 1 cubic metre bulker bags that are now a value-added product, which we can send off to separation plants, either domestically or internationally. If we can move to the next slide. I wanted to talk on tailings and radiation management, which of course is very important. So all of our solid residues go to a single neutralisation thickener where we do our final tests to ensure that it's chemically stabilised and well washed. What this does is it doesn't just ensure that the tailings are environmentally stable, but it also allows for a very high degree of water recycle within the process. The neutralisation thickener is combined with the mineral upgrade plant tailings, as I said, and then sent back to the pit. And we have undertaken extensive testing, chemical stability tests on these tailings to ensure that they are stable long term. In essence, the same stability as we've actually mined the material. Radiation, of course, very important. The rare earth mineral concentrate that we treat contains both thorium and uranium in elevated concentrations. The thorium and uranium are emitters of the three different types of radiation source. However, by far the greatest exposure has shown that the likelihood of any risk is in dust contamination. So we've gone to great lengths to ensure that our process is dry through the whole process with the exception of the acid bake. Hence, we have a very comprehensive 3-stage scrubbing process to ensure that dust emissions are well monitored and controlled. With regards to the rare earth mineral concentrate itself, that is a known larger source, so we will put in place through our radiation safety management plan demarcation areas. So where large quantities are stored, we will ensure that there is both distance and demarcation in terms of access. Which is what I've spoken about in the next point. Okay, now our process itself has been tested through the Australian Nuclear Science Technology Organisation, ANSTO, which is the government preeminent radiation facility and also happen to be the rare earth experts probably in the Southern Hemisphere. They've done a full deportment of radiation and what we call the decay daughters of the radioactive materials through our entire process to ensure that we know what is going where and it all gets neutralised and stabilised. And we have developed, as I said, a RMP, radiation management plan, in conjunction with our radiation consultant specialists to ensure that we are meeting best industry practice standards. If we go to our next slide, I think that's us covered there. So It is, yes. So what I'll do, I've covered a lot there, and my apologies for the level of detail, but I'll open for questions because I've gone through a fair bit there, I see.
I feel the spotlight's on me as well. You did quickly mention what the compound of uranium was. That comes out of the neutralizer residue process. I won't call it a plant yet per se.
Yes.
Could you quickly go through the various compounds that could form or is expected to
Certainly.
form?
Exactly. Yes, look, again, one of the reasons that we chose to use ANSTO Minerals is their background in uranium processing and their specialised skills. In essence, we need to ensure that we are making one of two compounds. The best compound we can make is what's called sodium diuranate, which is SDU. This is a very, very stable form of a uranium precipitate. The other form we can make is a uranium phosphate, which in essence is one of the forms of uranium as it comes from the ground. So either of those forms are fine. However, the sodium diuranate is by far the more stable form. So we ensure that we monitor how much uranium that we strip from our ion exchange resin, and then we stoichiometrically add the required amount plus an excess of soda ash to make sure that we make that compound.
Right, you've mentioned uranium. There's the other radioactive element as well too for thorium. What is that?
Exactly. Yes. Yes. Look, thorium is in some ways is much easier. Even though we have a lot more thorium, the thorium chemistry is well known, and it actually follows the iron very well. So when we went to that slide and when you look back on that, you'll see that we're adding hydrogen peroxide. And the reason that we add the hydrogen peroxide is to ensure that we oxidize both the iron and the thorium through to a very stable form. So we'll be forming iron hydroxide, and we'll be forming thorium oxide under those conditions. So the chemistry is well known, but again, we need to, and we will ensure that we monitor the thorium on-stream analysis, the thorium coming through. But ultimately, the proof is in the eating of the pudding, whereby we actually undertake periodically the environmental stability testing of the tailings. And this is where we go for long-term leaching of the tailings in the laboratory using a weak acid process.
In regard to the actual neutralised residue with the addition of lime to it, what would be the approximate volume of that compared to the input?
Yes, certainly. Just bear with me. I've got those numbers handy. We will have a washed water leach residue of 2,500 tonnes per annum, and our combined, what we call purified washed purification residue, is approximately 34,000 tonnes per annum. Now, the vast majority of that residue as a mineral is actually gypsum, calcium sulfate. And because we have a sulfate process, so any sulfate that carries through when we add the lime, it makes a combined gypsum product.
Does the material itself look anything like the mineral sand itself?
It would look actually visually quite similar, because whilst pure gypsum is very white, bearing in mind that we have iron staining on this, so it will be a crystalline brown material. So for the average person, with regards to our tailings coming from the hydromet, it will look very similar. However, when we add this back to the combined tailings, it is such a small proportion of the overall combined tailings that when we did our mineralogy, it didn't even show up because it's such as I say, a small proportion. So the quick answer to your question is it will look exactly the same, with the possible exception that gypsum is actually a known soil conditioner. So we would expect that this will actually probably encourage regrowth of that area better than the compacted material prior to mining.
Right, but the actual material itself chemically would be totally different from the original mineral sands or the other tailings?
The mineral sands tailings, I missed the beginning of Mr. Williams' presentation, but it's quite a small percentage of the total mass that we recover. I think it's, please correct me if I'm wrong here, Mr. Williams, I think it was about 4% or something that you recover of your mixed products. But the majority of the tailings is in the same form that we send back. As I say, then the rest that we send back from the hydromet plant is essentially gypsum.
Is there any facilities around the world where this particular residue is not mixed in with the tailings and treated as a different type of waste stream?
What we're seeing in recent times, the short answer is it is not common practice yet. However, it is not from a technical point of view. It's the fact that we are proposing to put a separation plant, a hydromet plant, I should say, adjacent to a mineral upgrade or a mineral separation plant. Most of the rare earth production around the world has been focused on hard rock processing, whereby you have a very, very high grade concentrate that is made from a high grade ore, typically 5, 6, 7% rare earths. So you do not have the vast masses of mineral upgrade plant tailings that you need to dispose of anyway. So the answer to that is there hasn't been an operations in place adjacent to the opportunities that we have at Goschen to build both next to each other.
Right. Well, it's probably fortunate that's the end of my questions because the video is dropped out.
Thanks.
But thank you for the answers, at least for me.
Ms. Bell, do you have any questions?
No, thank you.
Thanks. I notice Ms. Eastman has her name up. Ms. Eastman, Mr. Beer isn't available for questions from submitters. I'm assuming that's why your hand's up. So
Could I ask you to ask a question for me then, please?
Sorry?
Could I just ask you to ask a question of Mr. Beer then?
Well, put the question to me first.
I'm just wondering, he gave a list of a number of places that are going to have this form of processing in Australia and that Malaysia's not anymore. And I'm just wondering, are any of those on prime cropping land?
Ms. Eastman, I think that's something that you can make submissions about when you make your submission to us. I don't know whether we need to hear from Mr. Beer about that. Thanks, everyone. We might break now.
Sorry, Member Chair, I had a brief question to inquire whether you might be willing to put to Mr. Beer two very brief ones. Firstly, he referred again to a number of figures, whether it might be possible for those materials to be provided to us in a written form, as was the case for Mr. Williams.
Ms. Porter, I'm sure we can.
I'm sure we can. Well, I think we're all taking notes of what's been said as well, so we can follow up with Mr. Beer and make sure it's all committed to writing.
And yeah, so I can pass it on easily to the EPA. And then the second was the slides refer, or I can't remember exactly whether it was the slides or his commentary, refer to the results of extensive testings. And perhaps you might inquire whether those results of extensive testings are in the EES or technical reports and where they are.
Ms. Porter?
I have no objection to that question being put to Mr. Beer. He's probably best placed to answer it.
Mr. Beer?
Yes, indeed. Look, we've done standard environmental leach testing on the combined tailings, and I believe there's no issue with us providing those, but please correct me from the VHM team if that's not the case.
I gather not.
I'm taking it, Mr. Beer, from your answer that you're not aware whether they're in the EES. I can take instructions on that question myself. So.
Exactly. Yes, but yes.
Okay.
So just before we break, I appreciate that this is a question that has been asked by a different submitter, but my instructions are that this is a matter of great interest to submitters, and it would seem to me this information is readily at Mr. Beer's fingertips. Whether he could be invited to provide information about the examples he's provided as to whether they're on prime cropping land, that would be of great interest and assistance.
Mr. Porter?
I'm just not sure whether Mr. Beer is in a position to advise whether something is on prime cropping land or not. All I can do is undertake to make inquiries and see if we can provide an answer to the question.
I think that's the best way to deal with it. I'm not sure we're going to be assisted by potentially speculative answers to.
Of course, so I just thought that if that information is within his knowledge, he's researched these examples, if you could make that research available, that would be much appreciated.
Or to deal with that. See.
Thank you very much.
Is there anything else?
I'm sorry, just one other further question while I get some instructions in respect of a geochemist. Could I ask if you will be formalising the reasons for the decision, whether you'd be bringing that to writing?
I wasn't intending to, but if you require me to, then I'll do that. I'm bearing in mind that it's been recorded, so it's on the public record.
If we could have those written down, that would be much appreciated.
An observation that I'll have to give some thought to whether they're reasons or whether they were observations that led to a conclusion. I'll give that some thought.
Thank you very much.
I'm going to ask you any more. We're going to take 15 minutes. Thank you.
So frustrating.
I understand, Mr. Perrin, you have your hand up.
He's unmuted. He's been asked to unmute. That's an accidental hand up. No, he hasn't unmuted himself. Member Bell's back. I'll try and promote him. I've given him permission to talk.
Mr. Perrin, can you hear me? I will push on, Ms. Porter.
Thanks, Mr. Chairman. So I think we have a little bit of homework to do in light of some of the questions that have been raised, and we'll get on to that. I might also say that I don't doubt there'll be further questions that arise during the course of the hearing, and of course Mr. Beer and Mr. Williams will be available to respond. We might need to reduce further responses in writing so that we can keep track of questions and answers. So that brings me, really, you've heard about the proponent and the project. Now I wanted to come to the policy context, which of course is touched on in chapter 15 and part of the EES and part 2 of the Part A submission. Before I step through some of the policy documents I wanted to bring to your attention or emphasise, I did want to point out that both the Planning and Environment Act and the MRSD Act have objectives to facilitate development that has policy support. In the case of the MRSD Act, the relevant objectives are specifically to encourage, facilitate and foster mining. Now, obviously that's subject to the proviso that the environmental effects of mining are acceptable, and so I don't want anyone to think I'm saying once you've got policy support, that's the end of the case. Of course it's not. But it is a really important lens through which a project such as this is to be viewed. And so to that end, I wanted to take you to some of the policies that were referred to in the EES, but specifically hyperlinked in the Part A material. And first is the Critical Minerals Strategy, which is an Australian government statement of policy regarding critical minerals. Now, the slide I've got on the screen is a little hard to read at that resolution, but as I say, you've had that hyperlinked in the Part A, so you'll be able to get ready access to this document, which of course is a publicly available statement of policy. And you'll see that this framework to grow Australia's critical minerals sector notes that the critical mineral sector is well placed to seize the opportunities of the clean energy transition, thanks to Australia's rich geological reserves, its expertise at extracting minerals and its track record as a reliable producer and exporter of energy and resources. It then has a strategic vision, which is that by 2030, Australia has grown the geostrategic and economic benefits of its critical minerals sector, is a globally significant producer of raw and processed critical minerals, and supports diverse, resilient and sustainable supply chains. The objectives of the strategy are to create diverse, resilient and sustainable supply chains through strong and secure international partnerships, to build sovereign capability in critical minerals processing, to use our critical minerals to help become a renewable energy superpower, and to extract more value onshore from our resources, creating jobs and economic opportunity, including for regional and First Nations communities. Just stepping over to the next slide is just an excerpt from that same document. It's a little bit fuzzy at this resolution, but you've got the page reference there. And really this particular screenshot from the overall strategy, I wanted to bring it to your attention because it deals with growing the sector and moving into downstream processing specifically, where we can do so competitively, that being to capture more value, economic benefits and jobs in Australia while boosting our sovereign capability. And then there's a reference to modelling commissioned externally by a federal department that indicates increasing exports to maintain our market position for critical and other energy transition minerals as global demand grows. And there's figures there about the jobs and the GDP increase that could be derived from that type of work. And it also talks about building downstream refining and processing capability, and securing a greater share of trade and investment could generate additional GDP and increase that projected number of jobs. So there's an emphasis not only on getting the resource out of the ground, but also processing it rather than shipping it all off to be processed elsewhere, as being a component of the strategic aims of this strategy. I've then got on the next slide an excerpt from page 16, again a little hard to see. What this section is talking to is how the strategy seeks to prioritise policy support effectively by mineral. In other words, which are the critical minerals that are of concern, and the critical minerals that we really want to prioritise or target to meet the broader strategic aims of this strategy. And so to that end, there is a list of Australia's critical minerals list, which is published separately to this strategy and is updated more regularly than this strategy. And as you'll see in the precursor to the introduction to that list, the priority technologies for critical minerals are identified by their overall contribution to emissions reduction, or our security, energy and industrial priorities, technology readiness, contribution to Australia's long-term comparative advantage and national interest, and capacity to underpin our strategic partnerships. So they're the factors, if you like, that weigh into a determination of whether a mineral is critical in the relevant sense. And then, of course, there's the priority technologies that are aligned with Australia's critical technology statement, and it talks about some of those things we've already talked about, so batteries and battery components, rare earth, permanent magnets, and other matters. And so there's factors regarding other broader strategic priorities, and then there's technologies that are of interest that all go into what are the 26 minerals that are considered to be critical. And the point to be made there is that all of the minerals we're talking about in this case are in that critical list. I haven't got a slide that has the critical list, but there's a hyperlink to it in our Part A submission if you want to go to that. Now, there's then the Australian Critical Minerals Prospectus, and that's you can see the mapping on the next slide. And there is, again, a hyperlink to the broader prospectus in the Part A submission. The point to be made here is that there are effectively three, if you like, resource provinces highlighted there, and you can see we sit within the Darling, Curnamona, Delamerian province, and you can see the Murray Basin being identified there. The next slide, again, is taken from the prospectus, and that shows that this particular project is one of a very large number of projects or resources that is identified on the national map. And then, in fact, the prospectus has a sheet on this particular project itself. Now, again, that's not to say because it's in the prospectus, therefore it gets the rubber stamp. Obviously, we're all engaged in this exercise to go to the next step and look at, well, are the environmental effects acceptable? But there is express recognition at the national level of this as being an important project that contributes to the overall critical mineral strategy. The next slide goes to the state level. So what I was dealing with before was national strategic policy regarding minerals such as the ones in this case. But then we come down to the state level, and there is a mineral resources strategy called the State of Discovery in the state of Victoria. And again, this is a hyperlinked document and publicly available. All I've captured in this slide is some of the statistics at the top of the right-hand side about just how difficult it is to secure a resource that is going to be economic. So, for example, a 1 in 300 conversion rate at best from exploration to a mining development, 440,000 metres of exploration drilling on average to make a discovery, 1 in 660 being the likelihood that an early stage exploration project will deliver a tier 1 or tier 2 discovery, and then only 45% of deposits discovered ever get developed. Of these, 12 years is the average time between discovery and production. So just putting in context just how difficult it is to get to the stage we're at now, where we're seriously looking at an economic resource that's able to be exploited. The bottom part of the right-hand side of that slide is the areas of Victoria that are exempt from the ability to get a mining licence. There's two different categories that I don't need to go into, the green and the orange, but in total it's in the order of, I think around 21% of the state is effectively locked out of the ability to get a mining licence. So really, again, this is to sort of flesh out this point that to get to this point on a resource that you can actually get a licence for is not an easy thing. It's a time-consuming and expensive exercise to get there. Now, that was the state level, and I'm not going to go through all of the aspects of that strategy. I then wanted to come down to the regional level, and on this slide, I've got some excerpts from the regional growth plan for Loddon Mallee North. And you'll see on the left-hand side, under earth resources and mining, the mining of mineral sands, gypsum, sand and stone and gold, and salt extraction are establishing a stronger presence in the Loddon Mallee North region and are bringing economic benefits to the local economy. Further development of these industries will require suitable road and rail infrastructure, linking production with processes and ports for export. Just pausing there, the Ultimo facility is a significant aspect of this particular project as well, the fact that it's there and available as heavy rail infrastructure that we can make use of. And then the next part of that excerpt, consideration is required to provide suitable accommodation for a mobile workforce that exhibits cyclical housing demand. And you'll hear from Mr. Weston through the evidence about social impacts on that topic in particular. It will also be important to capture the benefits that mineral sand mining and salt extraction industries can bring in terms of population change and growth. And again, that's something that'll be the topic of social impact assessment evidence. Then on the right-hand side of that same slide, there's a discussion on future economic land use strategies and actions. Granted, a lot of these don't relate to mining, so I'm not going to go through all of them, but I have highlighted there's 3 bullet points that do pick up relevant matters from our perspective. So the first highlighted component, protect major infrastructure, industrial land and mining activities from encroachment by incompatible uses. Second from the bottom, support and develop emerging and potential growth sectors such as nature-based tourism, mining and renewable energy generation, and protect these activities from urban encroachment. And the last one, identify, manage and facilitate access to locally sourced natural resources where appropriate, including sand and stone, minerals, timber and renewable energy. Now, granted, this is not a case about urban encroachment coming towards this resource. That's not a relevant aspect of this proposal, but those matters go to the alertness at the regional level that this is a particular economic sector that is or could be really important for the economic growth of regional towns, and is something that should be kept available and exploited where possible. The next document is the Gannawarra Shire Council Economic Development Strategy. And I've just captured one component there. I don't think I've got a page number visible on that, so I can find the page number if you need me to. But really this is to the point under industry, the last paragraph. Additionally, the Mallee region to the northwest of the Shire is rich in minerals and rare earths. A mining proposal being promoted by Western Australian mining company VHM has the potential to create around 300 full-time jobs when the facility commences production in 2020, so the timing's a bit out there. The mine is predicted to have a lifespan of 25 years and will certainly provide a positive lift to the local economy. And that's page 6 of that document. I'm sorry, I didn't have a page reference there for your benefit. I've lost our screen, so we might have to look over here if we're following along in this room. Before I come to the next slide, I just wanted to summarise where we are with the strategic documents I've just taken you to, albeit very quickly. And that is that the exploitation of a valuable mineral resource such as the one we're talking about here is both generally and specifically consistent with national, state, regional and local policy context. Now, there are fairly general policy provisions in the Gannawarra Shire planning scheme that I haven't taken you to here, but are referenced in the EES at Chapter 15 and also in the Part A submission. But the point there is that all of those levels of government, strategic policy is supportive of where acceptable, the exploitation of a resource such as this. The emphasis on downstream local processing that I took you to at the national level is a feature of this project. And in considering the environmental effects of this project, it is relevant to note that there are broad economic and social benefits of mining this resource that are recognised in policy at all of those levels. So if we could just go to the next slide, and now this is going to be hard to see for people sitting and relying on that screen, but in any event, it's in the pack that we provided. This is Annexure A to the Part A submission. So when you step through the EES itself, there are various visual aids to the approvals framework. I wondered whether this was perhaps a more useful way of depicting it visually, because what it does is it shows you the mining licence area as distinct from the project infrastructure land and the transportation component. And then under those components, it tells you what are the approvals and what documents sit under those approvals at the various stages, and who's the regulator, who's responsible for those approvals in the colour coding. So it's quite a useful ready reckoner for if there's an aspect of the approvals framework you're interested in, you can look to this document to see well, which component of the overall project land does it apply to, who's responsible for it and what sits underneath it. And so you'll see that actually before I break that down a little bit more, I wanted to make the point that we are assessing the environmental effects of this project at a point in time. So that's before the project has undergone detailed design, and with the aim of assisting the Minister in the assessment of those environmental effects, which in turn informs a subsequent approvals process. In other words, nothing that happens here or through your report grants anyone an approval to do anything, and indeed even the Minister's assessment doesn't grant an approval to do anything. The aim of this exercise, called up by this tiny little act called the Environment Effects Statement that triggers off this huge piece of work, is to inform future approvals processes. Neither this committee nor the Minister, indeed, is the ultimate arbiter of whether an action is acceptable or being carried out acceptably. Rather, the committee and the Minister provide valuable advice at a stage prior to the issuing of approvals. And the reason I make that point is perhaps, we touched on it this morning with the discussion of a document that's come to light in response to a question asked by an expert witness. There will be some degree of iteration through this process, as there always is, about the information as it comes to light. Even when all is said and done here and you've done your report and it goes to the Minister, even that isn't the end of the process. It informs a future process that will have its own information requirements that attach to it. Perhaps a good example of that is native vegetation. You'll see through the incorporated document that there's a specific requirement for a native vegetation management plan that itself calls up consideration of native veg losses and then offsets. And so we'll have information at a point of time here that is liable to change before the approvals process is triggered, and there will be further requirements at that point under the Native Vegetation Management Plan, to take that example further, to have up-to-date information at that point in time. Now, the overarching document we have, and you'll see under each of the component pieces of the project, is the Environmental Management Framework. That is designed to be picked up in subsequent approvals. We've heard what the EPA has to say about that, and we'll be taking that on board and responding as to how you pick that up. But the aim of the EMF is that it's picked up in subsequent approvals, and that's why it's as comprehensive as it is, because it's designed to feed into so many different approvals. The approvals themselves incorporate plans, as I've alluded to, and then the approvals themselves are issued and enforced by multiple regulators. So, for example, with the mining licence, which applies to the mining licence area, that is if I call it a teal colour under on the left-hand side, you've got the mining licence. You'll need an approved work plan, which itself includes a risk management plan, a rehabilitation plan, and a community engagement plan. There's also the assessment and payment of a rehabilitation bond under all of that. And then over on the right-hand side of the screen, you see that it's the Victorian Minister for Resources and the Earth Resources Regulator that's responsible for issuing that approval. I've already indicated under the planning scheme for the project infrastructure land, you've got a planning scheme amendment with a specific controls overlay, an incorporated document that sits under that effectively becomes like the planning permit at that stage. But even then, there's still documents called up under that, if you like, approval, namely the development plan, the environmental management plan, and the native vegetation management plan. And each of those has its own head of responsibility. So you'll see the development plan needs to be to the satisfaction of the relevant councils. The environmental management plan needs to be to the satisfaction of the Minister for Planning, and the native vegetation management plan needs to be considered and assessed by the Victorian Minister for Energy, Environment and Climate Change, or DECA, the relevant department. There are, of course, some components that sit underneath all of the different pieces of land. So you've got the traffic management plan and permits under the Road Management Act and Road Safety Act underlies all of this project area. You've got the EPBC Act approval that sits under the mining licence area and the project infrastructure land, and so forth. I might also add that you're obviously going to hear evidence about radiation, and the point to be made here is that in relation to the mining licence area, we'll need a radiation licence, a radiation management plan, and a radioactive waste management plan, and a radiation environment plan. all to be signed off on by the Victorian Minister for Health under the Radiation Act. But that also applies to the transportation component as well. So you'll see under the Transport to Port of Melbourne, you'll need a radiation management plan and a radiation environmental plan that all deals with that component or that aspect of the approvals.
Just one question.
Yes.
That table, that wasn't in the EES, that's something you prepared.
No, it's a different way of cutting the same information. So the EES had uncolour-coded visual presentations of the approvals that are required in, I think, in various parts of the EES. We just formed the view that this is probably an easier way or a better ready reckoner of who's responsible for what in relation to what component of land. Now, I'll come to you on the mining licence area and the project infrastructure land and indeed the development licence as well in a moment, but that's, we thought, a useful exercise to understand the overarching framework. I then wanted to go to at slide 18, so the next document just sets out how the environment effects statement, how it all sits together. Now, before I come to the components of that, as I think I said this morning, in our submission, it's not the job of this committee to decide whether the EES itself was acceptable or appropriate or what have you. That job is the job of DECA in assessing the overall document and its fitness to be exhibited. They then make a recommendation to the Minister, who then authorises the EES for exhibition. Oh, I said DECA, I mean DTP. I'm sorry, I got the department wrong. I'm still catching up with the department changes over time. The point to be made there is that it's not something that you need to form a view on ultimately. Of course, it's relevant what's in the EES, what's the understanding of the project, how robust is the information my client is putting to you about the environmental effects. But you're not tasked with saying, should the EES have been authorised in this form. It's just not something that you're being asked to do under the terms of reference. Rather, you're being asked to assess the environmental effects of the project. However, of course, it is the purpose of the EES to identify the significant environmental effects of the project and to identify how those effects might be avoided, mitigated or offset. Now, just to do a quick walkthrough of the structure of the EES and what I'll say are really the critical components probably for this hearing. In the chapters, which effectively do the work of summarising the information or distilling it down to its most important elements, the work that sits underneath it through the technical reports. But there is a really important chapter that you'll we'll be coming back to through the day one and then the day two documents, and that's chapter 21, which sets out the environmental management framework. So that's probably a really critical chapter within the overall EES chapters themselves. And as I've said, we'll be looking to respond to the EPA's concerns about the enforceability of the environmental management framework through the approvals process as it pans out, and that includes the broader implications for any approvals under the MRSD Act as amended and the enforceability of the EMF, given that we've got a new legislative regime effectively coming into play in a couple of years' time. So that's the chapters, and the most important for our purposes in my submission being chapter 21. There's then a series of attachments, and this is where I'll break down the various components of the project land. So first you've got the draft work plan. Now that relates ultimately to the mining licence and the work plan under that mining licence. And if we could go to the next slide, that just pulls out the mining licence area that's the subject of the application for the mining licence. It has been lodged as a mining licence application, so the reference number is there, and it effectively picks up area 1 and area 2 as being the area that the mining licence will regulate through the work plan. Then we have, I'll get you to switch between slides, if you can go back a slide. Again, under the attachments, you then have the development licence application. Now that again is a licence application that has been made to the EPA and exhibited alongside all of this material so that you can advise the EPA about the development license application as it's been made. And if we go down to slide 20, you'll see, and I'll just ask Mr. Forrester to highlight the development license boundary, which is in red, sort of in the middle of that screen. Yeah, so that was a job of trying to indicate what the development licence pertains to. Specifically, it pertains to the power plant and the sewage treatment plant, and so that's highlighted on that screen. Then if we go back up to slide 18, and again under the attachments, we have attachment 3, which was the draft planning scheme amendment. And so if then we go down to slide 21, that picks up the area that is captured by Amendment GC 218 and the incorporated document under the specific controls overlay. Now, relevantly, you'll see there that what's missing in that image is areas 1 and 2, because they're carved out of the planning scheme process of approvals. They're carved out because they're dealt with under the mining licence. What this picks up is everything else. So it picks up the road alignments, the pipeline alignments, the pumping station within the project infrastructure land. Now, this is something that we'll need to come back to you on the pipeline alignment, because, of course, the exhibited incorporated document picks up the at the EES stage, the exhibited preferred pipeline alignment. But in any event, that shows you how the planning scheme affects the land and the component of the project that is picked up through the scheme amendment. Then if Mr. Forrester could go back to slide 18 again. So they're the 3 critical attachments for your purposes, because they're all matters that your terms of reference require you to provide advice in relation to. You then have the technical reports, which of course inform what then goes into the EES chapters, but also what goes into those draft and exhibited approvals documents that I've just taken you to. All of those, of course, are important. The ones you'll be hearing evidence about in this case are technical reports A and B, flora and fauna, technical report E, traffic and transport, F, noise, G, air quality, H1 and H2, the surface water component, I, the groundwater component, to some extent geotechnical, and linked to that P, rehabilitation and closure. They all link up particularly with M, soils and land resource. So they're, I suppose, all playing a similar part. And I missed agriculture as well, so you kind of can lump a lot of those in together. Then N, radiation, and O, social impacts. Again, in terms of emphasis, we would place a degree of emphasis on technical report P regarding rehabilitation and closure. That's obviously of very heightened interest in this particular community, given the agricultural purpose and use of the land now, and we say into the future. And so that is a technical report that I would draw to your attention, but all of the technical reports really have a lot of work to do in a case such as this. So that's really the approvals framework, and it was at this point that I was going to ask Mr. Forrester to step you briefly through the day 1 documents, appreciating, of course, that they're subject to change and we need to give you greater clarity on why certain things have changed. But I'll invite Mr. Forrester to take you to that now.
Thank you. I'll talk to tabled documents 89, 90 and 91 in doing so, which are the day 1 EMF explanatory report from the draft PSA and incorporated document from the draft PSA, respectively. You've heard from the reporter in respect of the EMF that it is produced and developed to be the repository of specific and identifiable management requirements, mitigation measures and monitoring requirements, with the intention that it and its contents be used to inform project approvals in respect of relevant activities and uses in due course. And it's been developed in accordance with the scoping requirements and is consistent with the ministerial guidelines for assessment of environmental effects, which provide EESs should include EMFs of this nature. In the day 1 document, of course, the IAC has before it the exhibited document with marked up changes intended to give effect to the extent possible recommendations from, in particular, expert witnesses and their written statements, as well as recommendations and to respond to issues raised in submissions made on the exhibition of the EES. There are, I suppose, three categories of changes then in this day one document. First, I'll describe as responses to those expert recommendations. The second, responses to submissions. And then finally, there's some changes made really on a legal review of the document to improve drafting, including having regard to some other changes made. I'll step through the structure of the document in talking to those changes and in brief terms. Section 21.1, the introduction to the document, really goes through those high-level matters that I've just spoken to and reiterated what Ms. Porter said earlier. So to move on then, section 21.2 identifies the approvals and statutory obligations which this EMF is intended to inform. Everything under the umbrella of the EMF in the diagram. It's important to note, as I scroll down to page 10 of this document, which is page 21-6 of chapter 21, that the EMF is made in the context of duties under the Environment Protection Act, in addition to a range of other relevant policies, guidelines, standards and legislation. The committee will be familiar with the duties under the EP Act. The EMF still talks about them as new prevention-based duties, but it won't be new to the committee to understand that the requirements of approvals will not amount to or represent compliance with duties under that Act, including the general environmental duty, and at all times it will be a requirement on taking activities in connection with the project to act in accordance with those duties. The EMF's been developed and further changes have been made in this day one document to pick up as a consistent theme in respect of each of the environmental matters that it deals with, the requirement to eliminate and to reduce risks of harm to human health and the environment so far as reasonably practicable. And the IAC will have observed one of the DPA's particular recommendations went to the particular use of that language, as well as other language to make the EMF really consistent with the terminology of the EP Act. So I'm pointing out that section 21.2.1 because, of course, at all times that will be one of the guiding for the EMF and for the project. Also because you'll see the first change that we can see in red ink reference to risks of harm within the meaning of the EP Act to make sure there's consistency between this document and that Act. The meat of the EMF really starts from section 21.3, which establishes requirements in respect of the environmental management system to be maintained. It exists, there is currently an environmental management system adopted by VHM, which is aligned with the relevant standard, AS/NZS ISO 14001 of 2016. Accordingly, the environmental management system will require processes of monitoring, performance assessment and continuous improvement through adaptive management in the course of activities as mitigation measures and other requirements are implemented. The environmental and site management plans are detailed at 21.3.2. Reference is made to, I suppose, those key documents, the work plan in the context of the mining licence, and then to the incorporated document in the context of the project infrastructure, to use a term that I'll come back to in due course. It's important to note for the purposes of the EMF and the way that day one changes have been made, the provisions of the work plan, which would be required by the MRSD Act and the MRSD Mineral Industries Regulations, which would in turn require the development of those plans set out at page 12, being the risk management plan, rehabilitation plan and a community engagement plan. The IAC has before it the draft work plan. It has before it a draft rehabilitation plan as technical appendix P. It has before it a draft community engagement plan. The risk management plan aspect of the work plan would be very much informed by the risk assessment processes, risk identification processes that have been undertaken in the preparation of the EES. There's references to the MRSD Act and regulations at the top of this page 12 of the Day 1 EMF, which really tie into the proposition that in preparing a work plan, it's necessary to apply all relevant environmental risks and produce a risk management plan to address or to provide detail in respect of how those risks will be managed. It's in that context that where we get the identification of each of the relevant subplans, the biodiversity management plan and the WIS management plan and so on, which we'll be referred to throughout the course of the process as being a part of the work plan. They're all tied back to the identification and assessment of risks. The rehabilitation plan will be a relevant matter dealt with in the course of our focus on the post-closure situation and the process to get there. And the community engagement plan will be a focus of the process in respect of the ongoing involvement of stakeholders broader than just the authorities, which will be directly involved in the future approvals, to include adjacent landowners, road network users, and other interested parties on an ongoing basis into the future. While I've got page 12 on the screen throughout, and then we'll note the reference to the incorporated document to the Gunawarra and Swan Hill planning schemes, which, as has been identified, relates to that project infrastructure associated with the road network and the pipeline route, as well as the pump station at Kangaroo Lake. The text that's highlighted in green on the screen before us now identifies that in respect of both the work plan and its subplans and the incorporated document, the scope and content of those plans will be driven by and be inclusive of the particular risks identified, environmental mitigation measures proposed, and management and monitoring processes proposed as part of this EMF. So ultimately, when it comes to the question of how do we have comfort that the requirements of the EMF will be carried through approvals and management of operations and so on, the answer is the scope, content, and direction of the relevant plans will be informed by this EMF as the EMF itself provides. 21.3.3 refers to the A18 permit in respect of the discharge or deposit of waste to aquifer. As you've heard, that's not a document, or the application for an A18 permit hasn't yet been made, isn't yet in draft, because it requires, amongst other things, us to progress towards a more detailed stage of design, and therefore, as agreed with the EPA through the TRG process, that hasn't been progressed. What has been progressed through the development of the EMF is particular high-level propositions in terms of how VHM would approach that permit and how it would approach activities conducted in accordance with that permit. We'll come back to mitigation measures which themselves would relate to that permit in due course. Section 21.4 deals with roles and responsibilities of relevant authorities in addition to those roles and responsibilities of VHM itself and its contractors and employees. Section 21.5 identifies the process of risk assessment carried out and its use and utility in informing approvals, plans and requirements. And then 21.6 deals with the mitigation measures. Now, the IAC is familiar with table 21.5. It has been addressed in, amongst other things, the IAC's request for information, as well, of course, as submissions and evidence. It contains mitigation measures in respect of a series of themes or environmental disciplines. First, with biodiversity and habitat, focusing on the minimisation, avoidance and minimisation of adverse effects in terms of flora and fauna. It will be observed that the mitigation measures relate to matters relevant to the project infrastructure land, roads, pipeline, route, and in that context, day one changes have been made to deal with the proposition that seeds or cuttings may be taken from impacted plants where appropriate, if there are impacts and as there are impacts along the pipeline route, and then specific provision for the rehabilitation plan to deal with revegetation of mined and closed portions of roads which would be part of the mining licence area and later returned as rehabilitated and revegetated land in consultation with relevant road authorities. The biodiversity related mitigation measures you'll see in the right hand column are primarily to be implemented through the biodiversity management plan within the work plan and the environmental management plan under the incorporated document. In terms of cultural heritage, focus again on avoidance or minimisation on relevant effects, both in terms of Aboriginal and historic cultural heritage values. A minor change made to ensure cultural artefacts in the broader sense are dealt with by relevant strategies through the mitigation measures, which in essence would complement the CHMPs required in respect of the project. Landscape and visual related mitigation measures focusing on matters such as screening, with day one changes requiring early establishment within 1 year of commencement of construction of vegetation screening, consistent with the relevant technical report, and changes in respect of lighting to ensure that insofar as they might involve nighttime lighting, activities associated with management of overburden stockpiles be limited so far as possible to daylight hours to reduce the requirement for that lighting or its spill. Traffic and transport has received a number of changes as a result both of the overarching changes to provide for certain and defined language, but also to ensure that local road users are in effect captured by stakeholder consultation requirements, in addition to changes to ensure that the permits in the same MMTP01 to ensure that those local road users are involved in the stakeholder consultation associated with the early stages, the development of the traffic management plan and its stakeholder engagement plan, which would be produced under the incorporated document. In respect of noise and vibration, perhaps the location of the most red ink in this document, quite a number of changes have been made here having regard to recommendations in the EPA submission, in addition to the recommendations of the noise experts. And in particular, the IAC will observe a focus throughout the red ink changes on avoidance and minimisation so far as reasonably practicable in all relevant contexts. So we'll see through mitigation measure NV01, mining equipment and its selection and use, then through hours of construction, work methods, and maintenance of roads, dealing with mine planning, the power plant and the pump station, through conceptualisation, design and then operation to ensure minimisation is the key and minimisation is the aim in every respect. Now, of course, the minimisation of risk of harm from noise emissions relates to not just turning down the noise, but focusing on where noise can give rise to impacts on the environment or on human health. And therefore, insofar as there are some drafting differences between the way that the Day 1 EMF puts things and the EPA's recommendations, while you'll hear about this in more detail when it comes time to receive noise evidence, we've attempted to use drafting which is consistent with the minimisation of risks of harm within the meaning of the EP Act, and in terms which we hope captures the intention of recommendations made by the EPA. For example, we can see on the screen in respect of the selection of quietest available equipment, where that's required to minimise risks of harm to human health and the environment, such that a choice of equipment which is not capable of giving rise to noise that anybody off-site could hear might not be caught by that requirement. The noise provisions are arrived at, noise mitigation measures are arrived at with reference to published standards and requirements, including the noise protocol, EPA publication 1834, and in respect of low frequency noise. A common theme across the mitigation measures is their implementation through a noise management plan. A new mitigation measure is proposed to specifically provide for that plan and what it must contain and address. The next series of mitigation measures relate to air quality. Similarly to the case in respect of noise, they're developed having regard to published standards and with the overarching requirement to minimise the risk of harm from emissions to air, from dust emissions, from other pollutants, so far as reasonably practical. Again, a number of changes are made having regard to recommendations of the EPA and Mr. Shepherd, the air quality expert. The extent to which the conclave report might assist in identifying further changes will be addressed in due course. I wanted to note the new mitigation measure here, AQ07, which relates to annual offers, an offer prior to commencement of the project and then annually during operations for sampling of rainwater tanks, having regard to a particular identified risk in terms of deposition of dusts to those rainwater tanks, and the way in which that might be dealt with through cleaning, first flush, downpipe diverters, and otherwise in accordance with agreement with the relevant landowners. Surface water, another category in which there have been particular recommendations given and reflected in particular day one changes. You again will observe the focus on minimisation of risks. You'll also observe the focus through the development of a surface water management plan and the balance of the mitigation measures on the management of surface water on site, management of any spill containment and treatment measures with regard to what can be done on site, and the management of construction with regard to what can be done through construction to ensure consistency with published and recognised standards. The groundwater mitigation measures then follow. Changes again have been made having regard to EPA recommendations. These mitigation measures relate to, in particular, the groundwater management plan and the tailings management plan, which would be developed as part of the work plan in due course. You have heard already the extent to which groundwater mitigation does relate to questions of detailed design or ongoing stages of design. Mitigation measures are proposed and changes have been proposed in the context of allowing for that ongoing process and for the processes of later permissions, including the A18 CN mitigation measure GW02. Importantly, GW04 provides for a connection to baseline groundwater monitoring and provision to deal with ongoing groundwater monitoring, including completion of an updated groundwater model as that's undertaken. The soils and land resources mitigation measures then connect to the risk management plan and the rehabilitation plan primarily. A number of changes are made here really as a consequence of recommendations from both Mr. Masters, who was responsible for production of relevant aspects of the EDS, including soils and rehabilitation impact assessment, but also the input of the agronomists whose evidence the IAC will receive. That's Mr. Shovelton and Mr. Sonigan, whose conclave statement's been filed. And so while I haven't read that, I can certainly indicate that the mitigation measures and their proposed changes have regard to recommendations both of Mr. Shovelton and Mr. Sonigan in terms of the investigation of soil conditions to a degree or in accordance with a methodology that's well suited to their agronomical perspective, and having regard to objective measures, and then dealing with soil stripping depths and treatments of soil while stockpiled, if at all, and then through reinstatement, having regard to the achievement of the overarching objective of the rehabilitation plan, which is to achieve equivalent or better agricultural output post-rehabilitation. a number of changes are made throughout the mitigation measures, which are fundamentally aimed at those propositions. Similarly, that's taken across through agriculture mitigation measures. While the agricultural mitigation measures also deal with traffic and potential interruptions to routes used by farmers in the area, there are particular recommendations from the evidence of Mr. Wharf in respect of the avoidance or limitation of temporary road closures during, in particular, harvest periods, but also to the management of those closure periods in consultation with adjacent affected landholders, such that if there are particular requirements for agricultural movements at particular times, and given the flexibility afforded by the proposed pipeline construction methodology, that would be avoided, such that agriculture would not be disrupted, or any disruption would be minimised. Radiation mitigation measures follow. They are subject to changes only at that high level in terms of dealing with the language of the Act and provision for certain language. Some changes have been made in respect of the social and land use mitigation measures, having regard particularly to recommendations of Mr. Weston and Dr. Wright in respect of human health and wellbeing in the latter context. That will include enhancement of requirements to deal with the relevant councils, Gannawarra Shire Council and Swan Hill Rural City Council, in respect of the recruitment of workers from outside the region and how they can be accommodated. You'll see that change at SCO1. There's a series of changes at SCO2 in respect of the proposed neighbour agreement strategy or proposition, which specifies, picking up on a matter raised really in the IAC's request for information, which specifies what was proposed in the relevant content of the EES in respect of that. There's then also the new mitigation measures SCO3, 04 and 05 in respect of the PHM Code of Conduct and Employment Policy, and then farmer wellbeing in response to Dr. Wright's focus on wellbeing in the course of her human health risk assessment. Geotechnical stability provides for the ground control management plan, which remains effectively unaffected. The rehabilitation and closure mitigation measures have received one meaningful change through the addition of mitigation measure RH04, which expressly requires the rehabilitation plan to include a quality assurance plan, including a requirement for periodic auditing, and an adaptive management strategy, which of course will be relevant having regard to the progressive manner in which rehabilitation is proposed to be carried out. Section 21.7 of the EMF deals with baseline environmental conditions and has not been changed. Section 21.8 in respect of monitoring is proposed to be the source of or the location in which it can be identified which monitoring should be carried out as a part of relevant management plans. So you'll see here, I'm just highlighting the sentence, monitoring programs would be refined and implemented as part of management plans as identified in section 21.3. There have been some changes made in respect of the table 21.7 monitoring measures relevant to the project. In large part, they are consistent with changes made to mitigation measures. There are specific requirements in respect of the traffic management plan, in respect of performance-based standards and a code of practice for truck driver behaviour, in respect of air quality, in respect of the deposition to rainwater tanks question, in respect of surface water, in respect of water quality monitoring, and that's to pick up on a particular recommendation of the there's an aquatic environment phase 1 desktop aquatic ecology assessment of Kangaroo Lake, which recommended particular monitoring at locations in and around the pump station. There's then some effectively tidy ups of propositions in respect of groundwater monitoring and modelling. and a change in respect of the agriculture and soils component of table 21.7 to link back to a requirement in the mitigation measures that from 2022 and in subsequent years, grain yield mapping be undertaken in order to establish the baseline to understand whether yields produced in rehabilitated mine areas are comparable to outside the mine areas and pre-mining areas. To just close off on the EMF, section 21.9 then deals with environmental incidents and emergencies. 21.9.3 provides for auditing, which will be relevant through a number of relevant matters, including traffic, noise, rehabilitation and native vegetation. Environmental reporting is dealt with, and then at section 21.10, there's a connection with the proposed community engagement plan in respect of its ongoing stakeholder involvement. Now, having gone through them at a high level, I've identified what changes have been made at that high level without reference to the particular source of those recommendations that matter forthcoming to be produced and which has been foreshadowed. I'll then talk briefly to the proposed incorporated document. The committee will be familiar with its structure, which proposes to provide the controls against which the development of particularly the pipeline and the relevant parts of the road network would be carried out, to the exclusion of other provisions of the planning scheme which might, but for this incorporated document, the application of the specific controls overlay apply. Day one changes to the incorporated document are in large part caused by specific recommendations of the Swan Hill Rural City Council. The IAC's got a table of the particular recommendations that it provided and which that's been carried through. The first category of changes in the introduction deal with making quite clear that the incorporated document is focused on project infrastructure and not the project itself, not the mining area part of the project itself, I should say. At clause 4, that's echoed in terms of particular changes to terminology that's used. There's a series of improvements to drafting provided to make sure that the incorporated document really is consistent with the balance of the planning scheme in its use of defined terms and avoidance of unclear or uncertain language. The IAC will note there is reference to the creation, variation and removal of easements. There is one location in which an easement may be required in respect of the pipeline route, and so that's been included here. The conditions at clause 4.2 are first amended to ensure that a concern or a submission to the effect that the EMF ought to be directly picked up by the incorporated document is addressed. 4.2.2 has been amended to refer to the EMF through requiring any plan required by the conditions of the incorporated document to address the requirements of the EMF, save for the fact that if there is any inconsistency with the Minister's assessment of the environmental effects of the project, the Minister's assessment will prevail. The next changes at clause 4.2.3 in respect of the development plan clarify that a development plan must be prepared. It must relate, or it may relate to stages or parts of the individual project infrastructure components, subject to approval by the responsible authority. And particular provisions in respect of how the when the development plan must be prepared or who must approve it are dealt with now down in clause 4.2.9. And that clause, 4.2.9, provides on an overarching basis that plans and documents listed in clause 4.2 above must be prepared and approved prior to the use or development of land or creation of easements, and again provides that they might be staged. So that'll apply in the case of the development plan. It will also apply in the case of the environment management plan provided for by clause 4.2.4. Again, that's made or amended to refer to the EMF and the minister's, to the minister's assessment. Native vegetation requirements have just been amended in relatively confined ways. The requirement for details consistent with the guidelines for removal, destruction or lopping of native vegetation are retained, and of course will require reporting on avoidance, minimisation and offsetting requirements to the Secretary of the Department. But insofar as the incorporated document provides that in exceptional circumstances that Secretary may vary the timing of the offset requirement, and a provision has been included to provide for Gannawarra Shire Council or Swan Hill Rural City Council as relevant to be notified as soon as notification is received of that decision. I believe that was a recommendation of Swan Hill Council, and it's certainly something VHM supports, such that the council, as the local responsible authority, can be kept abreast of requirements in respect of offset requirements. Other conditions at 4.2.9 I've taken you to. Clause 4.3, which relates to preparatory buildings and works which may be undertaken before clause 4.2 requirements are satisfied, remain, as do the relevant expiry provisions of clause 4.4. Tabled document 90 is the explanatory report, which was exhibited as part of the draft PSA. Some changes have been made to it. I don't propose to take you to each of those changes because they are self-explanatory, but they are primarily made in response to, well, they really are made in response to the recommendations of the Swan Hill Rural City Council in respect to what's contained in that document. There remains some tidying up to do in really the incorporated document, as well as the explanatory report in respect, for example, of the numbering of the SCO mapping and so on. We might address that as appropriate towards the conclusion of the hearing and its relevant provisions, otherwise a more settled.
I'll just foreshadow that we may have some questions about the operation of the incorporated document. If we don't get those to you this week, it'll be early next week. It's really just to understand the mechanisms within it.
Thank you.
Thanks to Mr Forrester for giving me that break. If I could get Mr Forrester to go back to the opening presentation, I don't have much more to go, I'm happy to say, and I really just got two specific issues to address. So slide 22, we appreciate that the treatment of local roads is of concern to submitters, given the way in which they work and travel through this area. It's dealt with in Chapter 10 and in the Transport Technical Report, letter E, and also in paragraphs 44 to 56 of the Part A submission. I'm really just going to go through what's said in the Part A submission, but with the benefit of the relevant figure in front of us. So the figure in the EES in the small excerpt shows the overall potential for road usage and upgrades all the way up to Ultima. But in the larger image, it focuses in on Area 1 and 3 and the roads surrounding that mining licence area. Road closures would be required to allow for mining within the mining licence area, and specifically, and you can see it in the light blue on the map that's on the screen, in Area 1, so the southern portion, a section of Bennett Road between Polar Road and Shepherd Road, approximately 2 kilometres, would require closure from the commencement of activities, and that's the southern light blue line there. And then in Area 3, a 1 kilometre section of Thompson Road between Shepherd Road and Bish Road would require closure from the commencement of activities in Area 3, which is notionally 8 years after the commencement of operations in Area 1. And that's the northern blue line that you can see on the screen there. There's then a section of Shepherd Road between Bennett Road and Jobling Road, which will require closure for a shorter duration as services are installed within the utilities corridor. And sorry, that's the green. Yeah, the sort of the light or the vibrant green that's in the middle of the image there. The specific roads to be used for site access would be determined through the development of a site access strategy in consultation with stakeholders, including landowners and authorities, and controlled by a transport management plan. And you'll see that we're talking about including local users as well in that type of consultation exercise. Upgrades to public roads, including having regard to impacts of road closures, would require agreements with road authorities, and by staging project activities to minimise inconvenience to local residents and businesses. And again, that's subject to a separate process that we'll obviously need to go through. Road reserves would be rehabilitated on completion of works, and roads within the mining licence area ultimately reinstated following completion of mining. Now, while you've got a number of transport route and road upgrades delineated in the hatching on the plan there, at this stage it's anticipated that Bennett Road would provide the main point of vehicular access and egress to the project during construction and operations, and would form the first leg of the haulage route to the ultimate intermodal terminal. And so we expect that that's going to require upgrade, including by sealing. Jobling Road may be used to enable a secondary site access. So Bennett Road is the lowest of the hatched lines on the screen. Jobling Road is the next one up. Shepherd Road would provide a route for public traffic diverted around the mine due to the closure of Bennett Road. But at this stage, it's not proposed to use that top hatched line along Mystic Park, Metean or Bish roads, other than if they become required for detours when mining in Area 3 commences. So on that basis, we don't anticipate that upgrades to those roads would be required, other than to support their use for such detours if and as necessary. So I just wanted to make that clear, appreciating we've got a number of local residents watching on, and that can all, the detail I've just given to you can all be found in the Part A submission. And that then brings me to the last matter, which is something we've already touched on today.
Sorry, just before you move on.
Oh, yes.
From transport and the roadworks, and this is just really a general observation. And it's probably something, or not, it is something that I'll discuss with councils when they make their submissions. Yes. It's not clear from reading the EES to what extent the councils have been involved in discussions in relation to the TIA, or how aware they might be of their role in terms of the traffic management plan, which is that secondary consent process that you're talking about. It will be that they're across it and there have been ongoing discussions, but it just wasn't clear from the material that I've read. So some clarity around that, either from yourself or in conjunction with the councils.
Well, we can give you our perspective of that, and I'm sure councils can give you their perspective on that, but I'll take that on notice. Thank you for that. So the last slide is the matter we touched on earlier this morning, which arises from Dr. Callister's evidence in relation to flora. So I think, as you've already appreciated, section 4.6.5 of chapter 4 of the EES addressed the three options that were explored for the water supply pipeline route, between Kangaroo Lake and the project site. Now, it was already the subject of modification within the EES itself, and that was based on a flora and fauna assessment, on the flora and fauna assessments at the time, to avoid removal of native vegetation and habitat. On the slide, you can see A1, which is the leftmost or most blue line on that slide. And that was the original pipeline alignment. Then there were two alternative alignments explored. A2 is the middle one. Again, I suppose I'd call that probably not really a teal, maybe a vibrant green. And that is an alignment along Mystic Park and Beauchamp Road, then north up. I don't know how you say this. I'm sure the locals will tell me I've got it wrong, but Lochran Road is the way I would say it. And that's that middle line. And then A3 is Mystic Park, Beauchamp to Teagues Road, because that continues on from Mystic Park and Beauchamp Road, and then north up Lookout Road. In the EES, A3 was identified as the preferred route because no trees would be lost along Lookout Road and Teagues Road. And in fact, in the chapter I've referred to, you can see the photo of the difference between the two alignments in terms of trees. However, Dr. Callister in her evidence explains that more recent data through further field surveys in January 2024 following good rainfall has identified an area of an EPBC listed community, the natural grasslands of the Murray Valley Plains along A3, which is currently the exhibited preferred alignment. that finding increases the impacts on native vegetation removal as outlined in her evidence in table form. In order to reduce those impacts by 1.689 hectares and to avoid the EPBC listed community, she recommends A2 instead. As I've said to you, we need to address the impacts of if we were to go ahead with A2 rather than A3 through the relevant evidence. I do note that the noise technical report did consider A2 and A3, and effectively the impact is on a different dwelling, but it's a largely similar impact. So noise, I think, is probably something that is documented already, but we appreciate that there may be other impacts, and so we're making inquiries of our witnesses in that regard. We would also note that while A2 has a lesser impact on native vegetation in the sense that we now understand this EPBC listed community is present, it arguably has a greater impact on people, the local users of the road network. Now, we'll come to you on this, but the pipeline construction piece is a relatively fast-paced, when compared to the mine overall, it moves at pace and it moves across geographically. So once you've done the work in one bit, you move on to the next bit and so on. But there is a degree of disruption that would be involved if A2 was to be preferred. What I've asked my client to do is to explore the various options. It might be that there is a way of doing, of remaining with the A3 alignment, for example, but using different techniques so that you don't disrupt the grassland community. I don't know. We're exploring that and we'll provide further information to you on that. But at this point, as I said this morning, we don't have a preferred alignment at this point until we get that further information. Now, this is one of the examples of the iterative process that we're all engaged in when we look at the environmental effects of a project, because of course, with the inflection of time and different meteorological conditions, you do get different field survey results from time to time, and this is an example of that occurring. So we're doing our best to provide as useful and relevant information as we can to the IAC to inform your deliberations. That's really all I had to say to you. I feel like I've spoken probably far too much today, but we're a little early to finish. We were intending to go to you tomorrow on straight into the evidence and the summary, the opening summary that I indicated we would be providing, and then the presentation of the witnesses. We do have a conclave report, which I understand is quite a useful document in the sense that there seems to be a degree of agreement between the experts. So hopefully that'll assist all parties. I should indicate that I won't be here tomorrow. I am required in another jurisdiction, unfortunately, just for tomorrow, and I'll be back on Wednesday. But Mr. Forrester will be very ably driving this train or ship or whatever this is.
Thank you. I just want to go back 60 seconds and just ask you a question about a comment you made about the A3.
Yes.
I appreciate you're going to provide us with more information, but you were talking about investigating possible alternative construction options for the A3. What specifically?
I don't have instructions about that yet. It's something that I've asked my client to look at, given each one has more or less of an impact depending on the theme or the concern. And so I've asked my client to get some instructions on.
Yeah, that's fine. I was just it piqued my interest when you said it, so I was just interested to see whether there was something specific.
I suppose it's fair to say we are alert to the fact that it's not as simple as just saying, oh, well, the flora evidence is this, therefore you switch to the other alignment. There are different impacts and we need to give you information about that. So that's very live in our minds.
Okay. Thanks. Well, unless there's anything else, that brings us to a close for the day. Thanks, everyone. We'll look forward to seeing you all tomorrow. And tomorrow we're hearing from Mr. Masters in Soil Management and Rehabilitation and Mr. Shovelton in Agriculture. And we understand that their presentations have been uploaded and are available. We'll have a look at. Okay, thanks everyone. Thank you.